GPA オープンセッションにご参加の皆様、こんにちは。日本の個人情報保護委員会委員長の丹野美恵子でございます。今回 G7DPA ラウンドテーブルにおける DFFT の議論についてご紹介する機会をいただきありがとうございます。また GPA 年次会合をホストするアレクサンダー・ホワイトコミッショナーをはじめ、バミューダプライバシーコミッショナーオフィスの皆様以内をはじめ GPA 執行委員会の委員 GPA 事務局の皆様のご尽力に対し心より感謝を申し上げます。さて G7 においては年1回各国のデータ保護プライバシー機関 DPA の委員長級が協議する G7 ラウンドテーブル会合が開催されています。今年は日本が G7 議長国であり、当委員会は本年6月東京において第3回 G7 ラウンドテーブル会合を開催し、私が議長を務めました。本会合では DFFT 先端技術執行協力という3つの柱に基づき議論を行い、成果文書としてコミュニケ、行動計画、生成 AI に関する声明を発出しました。まずコミュニケですが、 G7DPA のハイレベルの対外的メッセージになります。また行動計画はコミュニケに対応した G7 実務者間の具体的な協力内容を定めたもので、 G7 ラウンドテーブルでは今回初めて作成されました。さらに生成 AI に関する声明は、生成 AI 技術に関しデータ保護プライバシーへのリスクに対する懸念が急速に高まったことを背景に、コミュニケとは別に特別に輩出された G7DPA のメッセージです。この場ではこれらの G7 成果文書のうちコミュニケと行動計画の DFFT パートに焦点を当てます。まずコミュニケです。コミュニケの DFFT パートにおいては、主に個人データの高水準の保護を含む信頼性の確保がデータの自由な流通を促進するための基本的な前提条件であることを確認しました。そして各国における個人情報保護法制の多様性を認めつつ、事業者が自らのニーズに合った越境移転ツールを選択できるよう選択肢を創出することが必要であること、そのためグローバル規模のデータ移転ツールの開発についてさらに提唱し促進することを目指すことに合意しました。次に行動計画です。行動計画の DFFT パートにおいては、主に DPA や OECD などさまざまな国際フォーラムにおける DFFT の概念を発展させるための進行中の取り組みをサポートし、信頼性が必要不可欠の要素であることを G7 として引き続き強調していくこと、グローバル CBPR と EU 認証の要件の比較やモデル契約条項の比較を通じ、移転ツール間の総合運用性及び修練の水準を評価し、共通点、考えられる相違点及びさらなる改善のための領域をマッピングすることに合意しました。さて次のセッションは、さまざまなデータ移転メカニズムを推進する担当者や専門家が一堂に会する貴重な機会と聞いております。DFFT の具体化に向けた有意義な議論が行われ、グローバル規模のツール開発に向けた協力が一層促進されることを期待します。最後になりますが、 G7 コミュニケの一節に DFFT は現在同志国及びさまざまな国際フォーラムの共通目標になっているとあります。今後とも G7 が共通目標である DFFT を会場の皆様をはじめ世界の皆様とも共有し、その具体化に向けて一緒になって取り組むよう私も尽力してまいりたいと思います。ご清聴ありがとうございました。
Good day, everyone. I am Dr. Lucy from Nova, Innovation Policy and Training Officer for the Office of the Privacy Commissioner for Bermuda. I hope you enjoyed your lunch and got to mingle and relax a little bit. Also, just a minor note, we will make sure that the subtitles to this video will be uploaded on the YouTube channel after this panel and the conference. Up next is data transfer mechanisms. The panel will be moderated by Ms. Bojana Bellamy. The panel aims to capture various developments regarding international data transfer law, policy and practice, and to discuss the shared path forward. Without further ado, Ms. Bellamy, please begin when you're ready. Thank you.
Thank you very much. Actually, I'm just going to stand up as I introduce this panel, and then I will sit back. I just feel a little bit more connected with the room. Ladies and gentlemen, thank you very much for coming for what is always the most difficult session after lunch. The sun is out, and we are in Bermuda. I mean, there's so much other lovely things to do than perhaps talk and listen about data flows. But I'm really glad you are here. We do have the longest panel in the history of GPA, and we are absolutely delighted to have that record. Yesterday was the record for the shortest answer. If you remember, Uli Kelber said yes. So today, somebody has to say, okay, that's what we need to do, but we will get there on time. We do have an amazing group of panelists today, and it shows you that everybody wanted to be here. Everybody wanted to have their point of view aired out there. And of course, we've got a very diverse panel, which is really important for the topic that we are going to talk about today. But let me first of all say great thanks. They're not customary, they come from the heart, to Alexander White and his amazing team, but also Inai and the executive committee for putting this conference together, for hosting us in amazing Bermuda. I think this topic is particularly well suited for your amazing country that actually thrives on flows of people, flows of goods, flows of data, flows of ideas, is in between the world, in middle of the ocean. And if you don't have data, you wouldn't probably have anything anymore. So I completely understand that. So thank you very much. It's been inspirational to be here. I would also like to thank the Global Privacy Assembly for actually listening to experts, people who are not privacy regulators and supervisory authorities, but are experts in the field. I sit in the Global Reference Panel. That was also mentioned yesterday. We really appreciate the outreach, the exchanges, the constructive engagement with all of us. We are here to help you, to serve you as well. So thank you again for allowing us into your world. Our worlds are actually together, right? There are no two worlds. We are in this really together. Now, you're asking yourself, why are we talking about data flows, right? And why, again, don't we know everything that is to be known about this topic? And I would say, yes, we do. Yes, you do. And therefore, we are not going to do the basics. We are not going to do ABC of what adequacy is, BCR, contracts. Actually, it is ABC, isn't it? It was not intended. It just occurred to me now. So what we would like to do on this panel is actually to take us forward, right? There have been developments. We have got some tools. How do we take this forward? What concretely can we do? What concretely can each of these panelists who have got important roles to play do to take us forward? And what can you, as Global Privacy Assembly, do to take us forward to solve this once and for all? And why are we talking about this now? Forgive me, but I need to remind us. We are at the inflection point. We understand absolutely the developments and the importance of transborder data flows and what has happened in the past few years in terms of policy, law, and compliance. On the one hand, legal restrictions on data flows exist everywhere. IPP has counted, I don't know, 100+ countries have got these kind of rules. We've got 20 kinds of standard contractual clauses, and it has been complicated by mixing the government access to data with commercial data flows. And all of a sudden, we found into ourselves in a sort of between the rock and the hard place, where these restrictions have been much more complex and difficult to comply with because of the government access aspect. Secondly, we've got the rise of localization requirements. Some are explicit, requiring data to stay in the country. Some of our scholars here, Alex Joel, has been working on this, right? But some are implicit, some are de facto localization requirements because the marketplace is responding to difficulties in legal restrictions, but saying, do you know what? I cannot be bothered, we'll keep data here, and that's not good for anybody. And I'll tell you why. And then we have got something which somebody else has actually called the legal arms race for data. There's a great article by Bertrand de la Chapelle and Paul Fellinger in 2016. It was a Commission for International Governance Innovation at Chatham House. And what they talk about there is that it's a principle of reciprocal diplomacy, which is very well known in diplomacy. And when one country does something, other countries follow. And so what they're kind of saying is that what we're seeing now in the internet governance is this very dangerous space where the lack of coordinated and cooperation action leads to actors, so countries, putting in place unilateral tools, making short-term decisions which look like they make sense for themselves short-term, but in fact, in this immediate interest, long-term, through its cumulative effect, is suboptimal and detrimental to them in the long term. And what they say is that the sum of these uncoordinated and unilateral actions by governments and private actors can have unintended consequences. And I actually thought to myself, this is exactly the space we are in data flows. A set of unilateral actions that we think are beneficial for us short term are actually making it suboptimal, and unintended consequences are damaging to all of us long term, and we cannot have that. That doesn't work. And of course, add to that data sovereignty and geopolitical aspect of data flows. So that's really what has happened in one side on the inflection point. On the other side on the inflection point, I don't need to tell you that, yes? Data flows is absolutely essential. It's essential for our human progress. It's essential for our economic progress. It's essential for us, what we are as humans, as a society. COVID has showed us that. AI is showing us that we need data in order to have just and unbiased AI. We need data in order to ensure the south and east of this globe also has got access to data and democracy and education and everything else. So we need to ensure data flows, yet we keep restricting. And as Marcus Haider, our vice president, has recently quoted Galileo, yet it moves. Despite whatever we do, data is moving, will always be moving. And I'm delighted to also say that we at CIPL have actually published together with Alex Joel at the TLS University of Washington a set of 2 papers where we actually talked about the real harms of that kind of unilateral decisions of data localization. What are the real harms that happen in 4 categories, right? To people, society, and companies, and public sector from these data localization policies. So there's no doubt the data needs to flow, and it will flow, as Galileo has written on his prison cell when he talked about the Earth going around the sun, right? Despite the church heresy, honestly, data will flow. And so where are we now? The third aspect of inflection point is the fact that the momentum has built. You know, sometimes you need a crisis to actually start realizing where you are. And I think we have had a bit of that crisis with a number of events. And the momentum is positive. And we will talk about this positive momentum. My panelists here will give me their aspect of what they see to be positive. But we have got G20, G7 data free flows with trust. We have had US-EU data protection framework agreed. We've got OECD agreed government principles, trusted government access principles. Did we ever think this would have been agreed between 37 states? Well, no. We have interesting developments in global CBPR forum becoming global and being potentially a way forward with some need for upgrades. We've got SCCs contracts being mapped across the board to ensure this multilateralism. We've got some laws like UK Data Protection Bill having a slightly different approach, taking GDPR to 2.0 data flow situation, which I like. I think that's really good for everybody. And then we had lots of influential papers. OECD published a really important paper in April this year. German Marshall Fund did the same. UK government is going to publish a paper by the expert board on data flows, expert committee, and I know a number of people here sit on that committee. So I think there is a momentum, and what I'd like to do is we want to now discuss how do we capture and how do we capitalize on this momentum? What can we all do to take this forward, to help those companies, SMEs, government, lawyers, everybody who wants to participate in data economy but finds these legal spaghetti of mechanisms complicated, distracting them from doing real privacy work, dare I say. This is my provocation to you today. I would like our privacy officers to do privacy by design, ethical development of AI, responsible deployment of AI tools, training, awareness. I would like them to do that rather than papering data flows just because we decide again and again that some of our legal mechanisms don't quite work. So this is the challenge to this panel. I would like all of us to be pragmatic, solution-oriented, very short in answers, because we have lots of people, and there is tea after this as well, and I'm sure another lightning talk, in addressing with me constructively how we take this forward. And to start with our panel, let me introduce, first of all, Elizabeth Denham, who is Chief Policy Strategist at the International Information Accountability Foundation, but also is advisor to Baker McKenzie law firm, and everybody knows her from her previous roles at the UK Information Commissioner, as well as British Columbia. And Elizabeth, I would like to ask you to kick us off and answer the question which I'd like to ask everybody, and that is, what makes you optimistic that we can build on this momentum?
Thank you, and thank you for the invitation. Thanks for the hosting, Alex and team, and the GPA. Really happy to be up here with this mega panel, and thanks for kicking this off. Bojana has actually stolen all of the guts of my first answer, but what I'll tell you is, you know...
Repetitio mater studiorum est, which is repeat.
So, you know, we've been talking about data flows for 20 years. I'm looking at Marty, it's maybe longer than that. And I have been in the valley of despair, and I have been optimistic at times, but how do I feel now? I actually do feel there are some beacons of light. And the beacons of light for me are, it's a coalescence of a lot of initiatives and a lot of developments that take us here at the inflection point that Bojana's talking about. And I really think that it's the new framework, it's the new data privacy framework, which I think is stronger and more robust and actually takes two legal systems and finds that in terms of outcomes, they are essentially the same. So I think that's really positive. The other thing that's positive is in 2021, the Global Privacy Assembly issued a resolution that was signed on by 128 data protection authorities about government access to private sector data. So huge check mark. And on the heels of that work of the GPA came the OECD declaration on government access to private sector data, which chimed those two initiatives, the words, the resolutions, the declarations were very similar. G7 work on data flows with trust, some of the G20 work. I think these are really, really important. And so it really is a coalescence of a lot of voices and a lot of initiatives at the same time. And if we can't do it now, when can we do it? So beacons of light, still a long way off for any kind of multilateral or international instrument. So short term, medium term, I see some positives, but long term, I'll leave it to my colleagues.
Liz, let me follow up with another question to you in particular, which is, you see this now from the other side. I mean, you were a regulator, now you are advisor to businesses and you work with businesses. What's the message you're getting from business? I mean, are they optimistic about this, or are they a little bit growing their gray hair?
Yeah, there's a lot of gray hair. I think, so when I'm advising law firm clients, the second most popular question, the second question that I'm asked most about is data flows. The first concern of law firm clients right now is really a lot about AI, responsible AI, ethical deployment of technology. but the second most popular topic is data flows. I think that the big question I'm getting from clients is, should we stick with SCCs? Because most companies have actually taken up SCCs after the second invalidation of the agreement. So SCCs are everywhere, and in fact, SCCs have gone global. So I'm seeing global companies actually doing intra-company agreements. So in a way, companies have taken SCCs and gone global. So a decision is a big one for a company to then switch to the data privacy framework. Personally, and thinking back on my career as a regulator, I think the DPF actually encourages and initiates an accountability approach, a whole global systems approach to privacy and data protection. The SCCs feels like a paper tiger, but obviously the court has added to the requirements under SCEs for data impact assessment, transfer impact assessments. But at the end of the day, I think what companies have to do is going to be dependent on their appetite for risk, is going to be dependent on their processing, what kind of data they're transferring around the world, and whether or not really they're looking for a more public statement about the effectiveness and the comprehensiveness of their program.
Thank you. Well, why don't I go now to somebody who actually is a current regulator, and that's actually Bertrand Dumaret, who is the latest addition to our panel, but we're delighted to have the voice of European regulators who have also been thrown a little bit into the difficult waters, because you have to also understand what is the level of protection in these other third countries, as well as the companies who are doing the transfer risk assessment. But Bertrand, you were at the G7 meeting as well of data protection authorities, and of course CNIL is one of the leading DPAs when it comes to, has been always when it comes to data flows. But what makes you optimistic?
Well, thank you very much, first of all, Bojana, to have organized this panel and to have invited me. Yes, I feel fairly optimistic for several reasons. Transfer flow, data transfer flows is not only about economics on business plan. It's also about sharing the same values and mutual understanding. And mutual understanding is a matter of a dialogue between the several jurisdictions. It's also a matter of to really understand what are the values that are commonly shared. And in this respect, I feel fairly optimistic because, as Liz just said, there is a multiplication of fora where these discussions take place. Maybe from an operational point of view, you may think, well, this fora, they are discussing blah, blah, blah. But actually, most of these fora, and almost all of these fora, are focusing on one of the transferred instruments which are listed in the GDPR. So you have a division of labor, I would say. We know that GPA is actively working on model contractual clauses. The Council of Europe do also the same. In terms of certification schemes, the EDPB issued some guidelines. The global CBPR is working on it. And the J7 DPA roundtable initiated a work on certification schemes. And as to the BCR, there is this, or let me remind you that the working group, the G29 working group, has done some work, some time ago, but it's still relevant. So there is a division of labor. Another thing which, going into practical deliverable. And these deliverable are most of the time sort of mapping of the different instruments that are used in different jurisdictions so that, and that's my second point, legislators at the national, maybe at the international level or regional level, I would say, are able to see where are the discrepancy, but also where are the commonalities. And in this, and the second aspect that actually, legislators are more and more concerned about convergence between the different different approaches. You can see that, and this makes me fairly optimistic. You can see that in specific topics, such as protection of child, AI. So there is a real pressure on us regulators, from the policymakers, from the legislators, to have some improvement into these specific issues, which I think will lead to a more convergence, a better convergence in terms of principles. Once again, the funny thing with the CNIL is we are not full-time commissioners, so I'm a judge. So I sit in panels. Mm-hmm. And I can tell you that having sound and well-drafted principles are usually more efficient than very detailed bylaws or soft law or regulation. So the real issue is to have a convergence on principles. And when the principles are sound, then at the implementation and enforcement stages, things are much easier and legal certainty is much stronger.
Thank you. And actually, I like that distinction. So we are looking for convergence of tools, which certainly is happening, but actually, we really need to look for convergence of principles and underlying requirements, and I think we probably are much more near than we think. But there is devil in the detail. May I ask Nima Singh Giuliani now to comment from the US perspective, because you were championing global CBPR for some time. And is that the way to converge the principles? Is that what makes you optimistic, or are there some other things as well?
Sure. First, thank you so much. I'm very excited to be joining this panel and talking about this issue. Maybe I'll take a step back and talk about the optimism and then what I think is next, including with global CBPR. I think, as others have said on the panel, what is making me optimistic going forward is the evidence that we all can work together, have different legal regimes, but common principles, and build frameworks that work. And that's really the data privacy framework. It was much dialogue, it was much collaboration, and I think we've arrived in a moment where there's momentum. But I think a critical and key important part of the conversation, Brianna, this is something you and I were discussing last night, is not to necessarily get stuck in the technicalities, but think about the practicalities. And so with the data privacy framework, one of the things that's been central has been, how are we going to work with companies? This isn't about having a few technical solutions. It's about a solution that works for small and medium-sized businesses, a business in North Carolina or Alabama who may want to spread globally and needs an efficient way to transfer data. So one of the things that makes me optimistic is that with the data privacy framework, and I think within all of these conversations, we're really centering on how do we build frameworks that work, and how do we build frameworks that should work for businesses of all sizes, I think reflecting broader goals of economic inclusivity and economic equity. So I guess that's one piece. Mm-hmm. Looking forward, what's the solution? You mentioned the global CBPR system. One of the pieces of progress this year, another reason to be optimistic, is the announcement earlier this year of launching the CBPR forum that began in APAC, launching that globally. And that was, again, reflective of this broader sense that we can have different legal regimes, but with common principles, we can facilitate the data transfers, not to have the technical solution, but I think very much in recognition of the concerns we hear from a broad spectrum of stakeholders about the challenges with data flows. And how can we build something that is interoperable? How can we build something that is streamlined? How can we build something that is practical in today's world that actually meets the needs of people?
I like the focus on people, because I think this is what this is all about, ultimately. It's not about a PhD thesis or doing a theoretical paper, but it's actually about how do we protect people, and when data is flowing, what kind of harm may they be and what kind of protections we need for that data to flow. And I'd like to actually now ask the European Commission. You can see this is not Bruno Giancarelli. I mean, he does say a big hello to everybody, but he has been detained on really important, actually, business that is beyond data flows. It's Middle East and the crisis there. But Dolores Dozo is going to take his place, and she is a senior key expert for Latin America at the EU Data Flow Project. Now, can we hear from the European Commission's perspective, Dolores, what makes you feel optimistic, and how do we build this convergence of principles? I mean, can that be something which isn't just GDPR?
Okay, so let me give you 2 reasons why I think that I'm optimistic compared to years ago. First, as many of you already said, the conversation has now grown into a more global, more diverse, increasingly involving new actors, both from the private and the private sector. And as many of you already mentioned, the G7, the G20, and already the role of data protection authorities and their networks are having a more and more increasing and important role. So a few years ago, I think that this would have been essentially a transatlantic conversation in the sense of EU-US. But now we have a range of actors, but also more geographic representation. So now that we are all on the table, we can discuss with a global approach, let's say. So that's the first thing that I would say on reasons to be optimistic. And then the second would be that, of course, that privacy frameworks around the world doesn't have to be identical. No one wants that to happen. But it's for sure that today there's a better understanding on what are those key commonalities, those key elements that we all need to be looking for when regulating and when enforcing privacy. So that's my second reason to be optimistic. And I think that this better understanding has allowed, in many cases, to build bridges across regions, between regions, not only within regions, but between regions. And I think that that's the path that we are now entering into, passing through from the theory of convergence to the practice of convergence. So I think that, and what I mean by practice of convergence, I will give you 2 examples. First is all the work that several regions are undergoing and doing to somehow recognize equally or as equal data transfer mechanisms. In particular, SCCs, contractual model clauses, are a very effective tool. And for instance, Asian and European Union, there are several regions and jurisdictions that has this type of instruments. And that's a concrete improvement in practice that could lead us to global convergence, recognize as mutual and work on that, how to build that bridge between model clauses. And the second example is mutual adequacy arrangements, not unilateral adequacy decisions, but mutual adequacy decisions that could lead into a comprehensive area of data flows and secure data flows amongst two different regions, or countries, such as the current negotiations the European Commission is having with Brazil.
Okay. So I'm hearing quite a lot of convergence here, in the sense that you all talk about we're not looking for identical rules. We are looking for sort of outcomes-based rules almost. The key elements have to be there. And I remind everybody the excellent panel that we've had from Caribbean region, where the Caribbean privacy commissioners and practitioners have said to us, we cannot just import another law and patch it on top of what we do. We have to make it adaptable and appropriate for our country as well, for the kind of economy we want to be. And I think that really is important. I mean, that's already something. It's a step forward, I think, that realization. I'm going to now move on to Commissioner Yuji Asai from Privacy Personal Information Protection Commission in Japan. Of course, it was Japan's leadership and the late Premier Shinzo Abe who has set this visionary concept of free data flows with trust. And I know the Privacy Commission in Japan has done huge amounts of work to promote that globally. So we all now use DFFT acronyms, and we know what it means. So tell us a little bit about what are you working on at the moment, and what makes you optimistic, particularly from the G7 discussions that you've had in Japan recently?
First, great pleasure for me to be here with all great experts. This is honorable for me. So I want to start to say optimistic situation is already recent legal development on the personal data transfer. Globally, more than 160 jurisdictions have introduced comprehensive laws. I think level of data protection in the world becomes rising and converging. Mm-hmm. Of course, we see many problems. We may need a critical solution, but I would say we see optimistic situation around us. And important is to operationalize DFFT. Key is to implement technical approaches. In my view, there are 3 key mechanisms already we have. That is adequacy and certification and model contractual clauses. But these 3 keys in different aspects, but going to global approaches, not to stick into 1 country and 2 countries, 3 countries, and the regions. This is most important to see there is a momentum toward 3 approaches to global scale. So such growing momentum for development of data transfer mechanisms on global scale to operationalize of DFFT going on already. So that's why I would say, again, I am positive about operationalization of DFFT.
Excellent, and we would like to see more of that as well.
Yeah.
And thank you for all your leadership in that as well. Sometimes you need people and organizations to actually push concepts and do the work, and I think that's exactly what everybody here is trying to do. Let me now move on to our 2 commissioners from Latin America and, of course, Kenya. And maybe I will go to the Immaculate Kasait, Data Protection Commissioner of Kenya, to ask you what makes you optimistic in how data flows have evolved. But also tell us a little bit what's on the mind of data protection authorities of Africa when it comes to data flows.
Thank you, Bojan, and my fellow panelists for this opportunity to sit here in the panel to contribute to this very current issue on data flows. I think one of the issues that perhaps we have not talked about is technical, that would make us optimistic is the technical and organization measures, such as data spaces. We are seeing increasingly, we find Upspace bringing together data providers, users, and intermediaries. And they're all adapting mechanisms that actually then help in terms of data flows. I think that's a reason to be optimistic. Outside the intergovernmental and international conversations, that is something already happening in companies. Specifically for just thinking through in terms of Africa, of course, I have to say, perhaps the conversation around data flows in Africa has not been as robust as has been in the rest of Africa, of the world. We are happy to be in these spaces. First, as the first vice president on the of the Network for African Data Protection Authority, we are seeing increasingly African countries come up with data protection regulatory framework. That in itself is a statement of seeing how then African countries align when it comes to data protection. Two, we are seeing regional integration in the forms of the African Union, coming up with harmonizing digital policies and fostering regional integration. Just last year, the African Union came up with a framework on data protection. So that's a reason to be optimistic. Three, we see regional economic blocks in Africa, whether it's East Africa, ECOWAS, or SADC, promoting intergovernmental data flows. And they are all aimed at making sure there is harmony in terms of the digital economy within their specific region, because clearly there's a lot of trade happening within those regions. We've also seen, we also increasingly see an increase in terms of cross-border data transfer agreement, including bilateral agreements. Some African countries, of course, enter into mutual agreements within themselves. And the other one is multinational agreement, whether it is with the WTO or the African Free Trade Agreement. Something which increasingly at times can be controversial, but also happening within the African continent is data localization in data centers. And we are seeing countries encouraging people to have, to establish local data centers to keep them within the national boundaries. And of course, there is always a concern about national sovereignty when it comes to issues around data localization. Regulating of data localization is another issue that we see there is an increase in terms of storing sensitive personal data within countries. International data transfer, we've seen contractual, which has been spoken about, contractual clauses, and also binding corporate rules. Increasingly, we've seen a lot of collaboration, capacity building within the African continent. And I think realizing that it's not a choice when it comes to matters of data flows, it's a matter of course, because the only way to improve trade is to allow for free flow of data among East African countries. So there is reason to be optimistic. People are increasingly seeing the reason why you must then allow that flow, and that's why you're seeing an increase in terms of the framework, collaboration between different companies to see that issues around data flows become an issue of course. Right. Thank you.
Thank you, Immaculate. I think it's really interesting what you said at the beginning. I think that is important, which is the accountability and the organizational and technical measures that those who are transferring data, putting in place are really going to be hugely important. And I know many people are working on privacy-enhancing technology, privacy-preserving technologies, encryption, and these have got a role to play, as well as kind of access controls and other contractual measures that companies put. I kind of wonder whether we have forgotten a little bit about accountability as a transfer principle, and we can reconsider this. I do have a follow-up question, which I need to ask, which is, why do you think that African countries, some African countries, are also putting data localization on the agenda when you say this is not a choice? We know that this is a matter of trade, it's a matter of progress, but yet we want to localize data. So isn't that a contradiction? I mean, why do you think they're doing? Nobody knows. We can all guess, but what do you think?
I think many times it's always the question about balancing data sovereignty. That some of this information is extremely important to the country, and having information hosted outside the country, then what does that mean for a particular country in terms of data that has something to do with their citizens?
Okay.
Yeah.
And I think this is an interesting thing we have to consider, which I think, Alex, you have reflected in your paper, and I'm hearing, which is sometimes countries do have a justifiable reason to restrict data flows, or to be considerate about where data is flowing. We will talk about government access to data, but I do want to come to Beatriz de Anchorena, who is the director of the Data Privacy Authority in Argentina. And Beatriz, what makes you feel optimistic, and how does the amended Argentinian law look at this variation of different transfer mechanisms?
Well, good evening to everybody. I bring the opinion of the south of Latin America, and I really feel optimistic. I want to feel optimistic. And I think that is because the international community is having effective conversations and agreements to move forward, to have a diversity of instruments and tools for international transfers of personal data, no? And there's a consensus about the need to balance the protection of personal data with greater dynamism in data flows. I heard in this event keywords, no? Language is performative, no? And I heard interoperability, convergence, harmonization, trust, transparency, regulation, democracy, stakeholders, ethics as inputs and as outputs of the discussion around data flows. And so if these are the right words, we are in the right path. Of course, I wanted to go into what Argentina is doing about data flows. And in first place, I want to mention that when I took office in March 2022, I made a strong commitment to have a new data protection bill. Why is this? Argentina has a law from the year 2000. It was the first country in Latin America to have a data protection law, but we needed to update. And this is one of the things that we do. We are also in the process of evaluation of the adequation from the European Commission. We had the adequation in 2003, and now we are going again in the adequation. And of course, we are working in the standard contractual clauses in two senses. First, the Ibero-American contractual clauses from the network that Argentina is part, and also we participated in the standard clauses from the Convention 108 plus. So that also are a few steps that we are giving. And finally, I want to mention that we are having preliminary conversations regarding CBPR and certifications. What the new law or the new bill is promoting is adequation, certifications, model contractual clauses, binding corporate rules, and of course, some exceptions. So I think that we're modernized in a special chapter, chapter 3 of our bill, all the data flow strategy.
I like that. So I like the idea that, in fact, we have got a toolkit, and that hopefully the laws of each of your countries would enable a toolkit of data transfers that actually can be applied for different types of transfers, different companies. But it still is very complicated, you know? And I think my follow-up question to all of you is being, how do we help those on the ground find what that tool looks like? But before we go there, Alex, you are the last, very patiently. And I want to ask you what makes you optimistic, but also I'd like you to share with us, you're a scholar, you are somebody who has worked also in the national intelligence here in the US and has been the privacy protector of all of our rights. But what are some of the misconceptions or things that we should know about the world of data flows when it comes to government use of data today as well?
Great, thank you very much, and thanks for the opportunity to be here. I am very optimistic, especially after hearing all the comments on the panel. I do think that we are at a very special moment, and I love the metaphor of convergence, especially as it applies to the metaphor for the conference. I think of currents coming together, or actually I went on vacation recently and went whitewater rafting, and I don't know if people here have gone whitewater rafting, but as you go in the raft, there will be, turbulent waters, and everyone has to work together to get through those turbulent waters. And so I actually see two separate streams of work that are now converging at last. One of them has to do with commercial privacy, which has really been what this assembly has been focusing on and what data protection officials typically focus on. In the laws, as you know, of many countries around the world that have comprehensive privacy legislation, as I always tell my students, look for the national security exception, because there will be a national security exception. There will be other kinds of special provisions for law enforcement access to data. And yet you can't have trusted data flows unless you address what happens in that, within that exception, right? So you have all of the conversations we're having here at this conference and other places around the world where you're seeing a convergence of people around commercial privacy issues and looking ahead at things like AI. But we're also finally seeing more and more conversations around what happens in the national security side of the equation. Because again, you can't have true trusted data flows unless you trust that when the data goes to another country, the companies will continue to protect the data in the way that you feel the data should be protected as the originating country, but that also that country's government will not seek access to the data in ways that you feel are inconsistent or incompatible with the needs and values of your country. So you have to address both sides of that. And we're getting there. We've had some exciting developments. The EU-US data privacy framework people have mentioned already. The US made, I think, groundbreaking changes in its national security legal framework to address the concerns that the Court of Justice of the European Union had raised. And these were, I know that maybe on the outside they don't seem as dramatic. They were dramatic changes in our legal framework, right? So in our national security legal framework, which is a big deal. And then the OECD Declaration on Trusted Government Access was another groundbreaking moment where we had data protection officials as well as national security and law enforcement officials from OECD member countries come together and say that these are the principles that they all share in common in their own legal frameworks. So you asked me, like, what are some common misconceptions? I think one is that, and this is you mentioned one of the things that we did with SIPL on this. One is that data localization can effectively shield data from legal access by countries, by governments in other countries. Because as we all know, the current is flowing in the opposite direction. Governments want access to data that is stored in the cloud, to data that is stored in other countries. And there have been developments in the EU as well as with the Cloud Act in the United States. And of course, a while ago, there was the Cybercrime Convention. The momentum in that direction is how do we provide governments the ability to have a trusted framework to access data that's stored in another country. So I think this idea that you can localize data and shield it from legal access from other countries is going against the current of where our governments are going around the world. And I guess another broad misconception, I think, is that governments, when they deal with national security, are doing so in an unregulated way. Every country has its own complicated set of laws that restrict how the governments can carry out national security activities. I would say every democracy governed by the rule of law has those kinds of foundational aspects. They are difficult to understand sometimes. They require expert review and analysis in order to be able to better understand it. So I think, my hope is that people who are on these rafts going through the waters, as you converge, there will be even more turbulence ahead. We're already seeing some of that convergence. And I would hope that the people working on this don't develop fatigue. Don't decide, I've been rowing enough. I got other things to do. I'm going to, put the raft down here and go have a picnic or something. I know that's not what people are doing, but there's so many crises and so many calls on our attention. Yes. We have this momentum. The people working these issues are experts on them now. They know each other. Let's keep going. Right. And I think we can make progress.
And that's a great message. I mean, I have to say it is incredible, the achievement of the OECD Trusted Government Access to Data Principles, this declaration, and that has been agreement on this, and really kudos to everybody who was at that table. We know that there were lots of nation states as well as the European Commission and also those who are in the intelligence community. Alex, how do we get those who are in these different silos to sit at the same table and raft together? Because at the moment, they're all rafting in their own rafts.
Well, my hope is that we will have we have the Global Privacy Assembly. We should have the Global Trusted Government Access Assembly.
Right.
So we should be having a global conversation where representatives from the national security communities and the data protection communities come together. You have to have, you mentioned mutual understanding. I mean, that is so important. Data protection regulators have to understand not only how different every country is in terms of how it regulates national security, but also understand how their own countries do it. And I think there's a tendency among national security officials in all countries to make sure, no, this is our area, we know what we're doing, don't look at what we're doing because it's secret, everything along those lines. But we have to engage each other, be willing to meet each other where they are, understand what the protections are in place for national security and privacy. So I do think that with Japan's great leadership, the Data Free Flow with Trust initiative is a great initiative to continue to push this forward. And the OECD, having had all of this experience developing the trusted government access principles with all of the member countries, is a great place to also focus on.
I'd like to ask actually a question as to what concretely can each of you in your roles do to advance us from this good momentum. Maybe Dolores, I'd like to start with you because we've heard about the Cloud Act and negotiations. So we know that US has reached negotiations on the Cloud Act with UK, with Australia, and that is possibly an avenue for Europe as well. This is not about intelligence gathering, but it's about law enforcement access to data where companies are again in this space between hard rock and the hard, what is it? Hard place and the rock.
Rock and hard place.
You know what I mean. It's the Bermuda Triangle, that kind of stuff. This is where they all are. This is where they all are. So, can we expect some progress on that?
Sorry, I'm also on the triangle of the Bermuda Triangle. What was the question, basically?
The question was on the Cloud Act, on the Cloud Act. And can we have more bilateral arrangements so that some of these justifiable accesses to data can take place?
Yeah, of course. I mean, it will depend largely on the level of protection that will be on the other side.
But do you think after the US-EU framework, this is possible now to contemplate?
At this moment, at the present moment, how it's currently presented, I think no, but could be something to work on and to improve.
Okay. Everybody else, what are 1 or 2 or 3 things that we should be working on? Who wants to kick us off? Okay. Elizabeth, come on.
So I think we need mutual recognition of SCCs. So we talked about 20 different SCCs, and I think what companies are looking for is let's save the paperwork of privacy in designing SCCs, and let's instead use that resource. So we have mutual recognition of SCCs, and we can use that resource to really build legitimate, effective, accountable privacy programs. Because I really think it takes us off our game if we are just focused on SCC paperwork, addendum after addendum after addendum. So I really think let's be practical and let's look at mutual recognition. And just hats off to Japan for, I think, the first mutual recognition of an adequacy agreement between the EU and Japan. And I just think we need to get to a place where we are willing to mutually recognize these tools in the toolkit in a way that looks at outcomes and not necessarily process. So that's one thing. The second thing I would say really quickly is I think we need a real, robust discussion about risk. Mm-hmm. And that's something that the Information Accountability Foundation would be happy to host. And this would be a real discussion about how the fact that all transfers are not the same. Okay, so a transfer of, an IP address is not the same as transferring identifiable health information from a clinical trial. So can we have a real conversation about risk and not consider that all transfers are the same? Those are my 2.
Bertrand, can I ask you about this one? Why is it that people feel frustrated about this lack of risk-based approach as to how it seems European data protection authorities approach data transfers? And transfers are not all the same. I mean, government is not interested in every transfer, are they? But they're interested in particular transfers. Yet, even Google Analytics is subject to the same rules as perhaps communications data or financial services data.
Well, I will have several answers. Well, actually, maybe to one question which has not been raised.
Sure.
But you know, I mean, the panel this morning on risk was very interesting to see how actually it's difficult to assess what risk is. So, as a regulator, we approach this risk paradigm very prudently, I would say, given our mandate. One thing I would like to stress when you ask what should be done, I think we should, especially as a community of DPAs, maybe lay the stress on enforcement cooperation. And this is, by the way, another reason to be optimistic. I feel that the mood is very positive towards enforcement cooperation, and on a very day-to-day basis and ad hoc basis, let's say to connect Ugandan with Bavarian and with the CNIL in the middle and things like that. But there is a need, I think. I mean, clearly, most of our bilateral discussions usually are on enforcement. Yes, well, another thing is, data transfer impact assessment. That's, I think, a good methodology, and to develop, jointly with other DPAs. We will publish a methodology for TIA in the very next days or weeks on our websites for consultation. So when it will be released, really, I'd be happy to have all your comments.
Well, I hope very much that for both of your wish list, which one is enforcement cooperation, in order to do that effectively, there has to be, as Liz says, agreement on risk, because different data protection authorities have to decide that there is a risk and harm to individuals because of these data transfers. And we've seen that in Ashley Madison case, right? We've seen that in Clearview AI. Those were interesting international cooperation enforcement.
But we don't see the EU cooperating outside of that region. So I'd really like to see that.
Okay, as in kind of with other regulators not in the EU region, okay. But also, to your point, transfer risk assessment, if we want to see methodology of that, well, then we need to address the risk as well, in that as well, right? Hopefully that will be in the EDPB guidance or methodology.
Well, once again, I feel
Wait
very prudent.
Okay, we wait to see. Nima.
Sure, thanks. I want to go back to your question of what can we do? What do we need to do now? And just go through a couple of key issues, some of which I think other folks on the panel have touched upon. The OECD Trusted Government Access Principles. I think we need to continue this conversation and continue this momentum and progress on the TGA principles. A couple of things that are, I think, really key to that. One is conversations with non-OECD countries. This is something we've talked about and collaborated with the UK, and I know our team has talked to, for example, Argentina, Brazil, other countries around the world about these principles. We need to continue talking about them. But importantly, we also need to put meat on the bones. We need to make sure that jurisdictions understand what they would need to do to be in adherence with the principles. And so I think continuing this conversation and trying to all, I guess, to use Alex's metaphor, continuing rowing the raft in the same direction is important. The second thing is, we've talked about CBPR, but I think this focus on interoperable multilateral solutions.
Yes.
This has to be a conversation that's not just focused on a couple of countries or a couple of stakeholders, but really includes input from businesses, civil society, enforcers, policymakers. And that's, I think, how we're going to get to this interoperable solution. So I think the CBPR forum was built with that idea, and we hope and invite others, and would happily talk to any of you about the work on the forum following this. Privacy-enhancing technology and other solutions. I think that technology continues to develop, and we should think about in ways that encryption and other technological solutions can help us overcome some of the barriers that we're facing in the data flow space. And then finally, and most importantly, just to maybe revisit a point I raised earlier, is I think we have to meet small and medium-sized businesses where they are. It's one thing to have these very technical conversations. It's another thing to translate that so that people can actually use the guidance and understand mechanisms, and also so that we have feedback mechanisms so we know what's working and what's not working. And I think that that's something we all need to get better at, is making sure that what we're doing is comprehensible to the folks that matter most.
Let me ask you a follow-up question, because you are championing, and US has been championing and doing lots of work on both OECD principles and the CBPR. I mean, sometimes we hear criticism. The CBPR have been there for some time, and they need to be upgraded and updated to simply reflect the development in law and policy in the last few years. Is that possible? Is that something that will be planned? And would we be able to imagine a world where we would link OECD trusted government access to data principles into the CBPR and with CBPR, and then we would be able to answer the question, what happens, that Alex says, to data when it goes to these countries?
Sure. I mean, I think to take the first question is, once we launch the CBPR forum in April, there's work to sort of stand it up. We've committed to looking at the program requirements. I think everybody who's been a part of that process understands that the CBPR was launched in 2011 in APAC. The world is different. And that there is work that can be done on a consensus basis to try to address, to the extent that there are gaps or areas where updates are needed. So to answer your question, I guess, much more quickly, yes.
Good.
There's work. And I invite all of you, I invite folks to participate in that conversation, become an associate, become a member. Your second question, I think, about government access is a really important one. It's one that has come up in the data free flows with trust conversation. What is trust? And I think, this idea of government access has been something that's come up in the workshops we've had at the CBPR forum, where different stakeholders have discussed the TGA principles. They've discussed the increasing importance of addressing this issue. And I think it's possible that the forum could be a place where some of those issues can converge. What that looks like, I think we have to see. Obviously, the forum operates on a multilateral basis. It operates on a consensus basis. It operates based off of input from stakeholders. And so I think that there's a lot of work that needs to be done to understand how those issues would come together.
And I now want to ask the Commission, what do you think needs to be done? But can you also see the world where we could build bridges between certifications under GDPR and those in CBPR upgraded 2.0?
Okay.
I would have asked you that question.
Yeah,
or Bruno, if he was here.
Don't
so.
worry. So basically, first of all, certification schemes is also an element present in the GDPR. So it's not foreign or an external element. And actually, the European Union is currently developing a certification scheme. Second, I think that to be credible, a certification scheme, and to be really trustworthy for not only regulators and businesses, but also for citizens, it should be ensuring a certain level of protection. This should be based on a right-based environment, but also taking into consideration the different level of protection already established in current laws, which I think is not the case of the CBPR at the moment, because not only in Europe, also in Latin American countries, the level of protection established not only in Europe and in Latin America, also in Africa and in Asia, the level of protection that the CBPR offers does not meet the requirements of the level of protection that is established in our current systems. So this is quite important because when we are discussing a certification scheme, we cannot undermine the level of protection already given to our citizens. And also, just to conclude, I think that moving forward with commenting on your thoughts, on your reflections, if the global CBPR certification or the initiative of global CBPR would think of upgrade and update their certification scheme, perhaps it would be possible to talk about convergence also in certification schemes. Mm-hmm. But as it is now, I don't think that's possible.
Well, I hear positives and optimism there, so it's just about upgrading. Any other comments, Immaculate, please?
Just to say that often when we have conversation, it's CBPR, GDPR. Mm-hmm. What we are keen on is to see the African voice in this conversation.
Good.
So that our different data protection authorities coming into fold, having conversation. What are the commonalities, their efforts within the African continent through Smart Africa, the Network for African Data Protection Authority, the African Union, to also that we are not just recipients, we are also participating in a framework that actually then define who we are as an African continent and how we want us to make decisions in terms of moving forward. After all, in terms, we have the youngest growing population and a lot of potential in terms of this space of digital. And therefore, our voice in this conversation also needs to be given primary focus.
And we would love to have your voice. And I do hope that you will be participating also at this CBPR forum, representing that voice. Any other comments on this question as to what concretely we can do, Beatrice or Commissioner Alex?
So I never thought I would do this, but I'm going to read from the OECD Declaration, one of the preambular statements, which I never read before in my life, but now it's a very important one. It says, we recognize that where our legal frameworks require that transport-or data flows are subject to safeguards, our countries take into account a destination country's effective implementation of the principles as a positive contribution towards facilitating transport or data flows. So for me, the next step is to how do we take these principles and make sure that they deliver that positive contribution? How do, Nima talked about how do we put meat on the bones? How do we make that real? And I think as an initial step, it is to map out how do countries protect privacy as they access government data, the government accesses data in accordance with these principles, and then again, enhancing mutual understanding, making sure that people understand how their own country does this, and then how other countries do it, so that we can have a more focused and effective conversation on these issues.
And that would help also companies who have to do these transfer risk impact assessments, as well as data protection authorities. I understand the UK government is already working on its own mapping. I hope we'll see, well, we've seen quite a lot from US government in the context of the US EU framework. I want to make sure that there are comments or questions. Having heard what you've heard, what do you think we should be working on or we should do? Do you have an answer to the question I've asked the panelists? Anybody, please take the mic from the audience. Quickly, be quick, and you have to run straight to the front. Yes, please, gentlemen at the end, please run to the front. I don't know which microphones work. Quick, snappy questions and comments, please. Thank you. We have got 2 minutes. I think that's the one that works. Good.
Okay, thank you very much. The Cloud Act has been mentioned, and it's an important framework for cross-border data flow and cross-border data access. I have a question about the Cloud Act, if any of you can address. So the Cloud Act has been described as a model for international cooperation, but I will challenge that characterization because the Cloud Act was first designed for countries who share similar values with the United States, and it classifies the world into qualified governments and non-qualified governments. And it has been more than 6 years since it was adopted, and now we have only 2 countries that are qualified. So my question is, one, it is not scalable. It cannot be scalable to the 190-something countries. And if you think of the Global South and small countries, let's say Africa, they have no choice. That one, most of their data is stored and held by US companies, and the cross-border data flow mechanisms do not work. They have no mutual legal assistance system. The Cloud Act doesn't work. Companies do not reply to African countries in the voluntary scheme, and this reinforces the desire to localize data. So my question is, do you envision any kind of framework outside the Cloud Act that could benefit all countries? Thank you.
So I'll just jump in and say those are very important challenges. Those are very important issues. I know that people working on Cloud Act agreements understand that those are the challenges and those are the issues. I'm not aware of a magic bullet answer other than to commit to this path forward to find ways to come up with a framework that is rights protective, practicable, and scalable. It is part of the conversation that has to happen going forward. How do we do that? How do we make what happens with Cloud Act agreements, what's going to happen, with the e-evidence directive, et cetera? How do we make that scalable? But we have to remember that ultimately it also has to be rights protective.
Yeah, well, if we look for an instrument to make, our different jurisdictions converge, I would prefer Convention 108 plus to the Cloud Act.
Yeah.
Okay, but not all EU countries have even ratified the Convention 108, dare I say. But yeah, okay,
No,
it's a possibility.
I mean, yeah.
Beatrice and Dolores.
Sorry, no, just commenting, supporting. I think that we do not have perhaps to have new solutions, but work with the existing ones. And Convention 108 and Convention 108 Plus are the instrument which is binding for everybody. Obviously, it has not been ratified by all countries, but it is undeniably that given like in the next it's undeniably that through the years, its nature has turned to a more universal one, and more countries around the world are ratifying. I have Beatrice next to me, who Argentina has ratified Convention 108 Plus recently, and we have lots of examples, not only from Europe, but from Asia, from Africa, that has ratified Convention 108 Plus. So I think that that's the instrument it already exists. It's there.
Right. Another.
Yes. Just to make a comment. Yes, we ratified this year Convention 108 Plus, but Argentina is targeting a diverse set of instruments and tools. And that means to engage in dialogue with various stakeholders, national and international level, in order to establish clear rules and promote trust and transparency. But another key factor is to enhance cooperation among different regulatory authorities to maximize the exchange of experience and knowledge. And I think that the dialogue in the GPA is fundamental for that. Furthermore, also companies play a central role by implementing safeguards and using tools to ensure the protection of personal data. But I want to make a special comment because I think that also building state capacity, if we're talking about democracy and how we can strengthen democracies, we're looking forward to produce regulations and provide enforcement. And yesterday, there was a very pretty good discussion about the roles of policymaking and the roles of enforcement, and the need to switch roles sometimes. And I would like to say that it is important that the DPAs can cope with different rationalities and strategies. Political strategic view, technical analysis, dialogue with stakeholders, understanding the business model. We need a state that can cope with different functions, and the regulatory and enforcement capacities are crucial for economic development and innovation. I'm obviously talking from the point of view of a Latin American state, but to go forward in data flows, I think that we need to think with a contextual or a situational autonomy. So that was a message I would like to share.
Thank you, Beatrice. These are really positive words on which we are going to end this panel, because you are saying this is not a beauty context. I've heard that before. We need multiplicity of mechanisms and approaches and things that actually fit different legal systems and different sizes and types of companies. I have heard the wish list, which Liz started, but you all added to, which amounts to short-term solutions, mapping, mutualizing, standard contractual clauses. Perhaps BCR, nobody mentioned that, but that's my favorite. Let's mutualize that as well. Let's evolve, Jürgen, right? Those of us who've been pioneering this for so many years, we want to see this become something more than just a piece of paper, but actually accountability mechanism. We've heard about the importance of privacy-enhancing technologies and safeguards and security measures as well. We've heard about global CBPR potential. I'm super excited about that, and we have to work together and upgrade and build those bridges with those who are not in the system but are interested as well. We have to make sure that we've got the voice of everybody there, and Africa and Latin America and Asia, because that's frankly where the world is moving to. I'm sorry, we are a little bit too old and too old-fashioned sometimes. It's not just the US companies, no European. The world is moving east and south as well. And I've heard that we have to strive to perhaps multilateral, one-stop shop mechanism that actually would solve this. Liz, you call this Bretton Woods for data. I talk about New Deal for data, and maybe that's what we need, so that everybody has got a just access and just ability to use data. So with that, please, those of you fellow rafters, fellow travelers on the way over the ripples, waves, and currents, we have got data flow currents moving very fast, and we have to move with them, and we have to make sure we influence those currents as well. And those who are organizing the next privacy GPA, we know who you are. Please, can we have a panel on this topic together with the government and law enforcement, regulators, and community as well? And I'm happy to moderate that, and I'll do my best to ask hard questions and get some very good answers. Thank you. You're brilliant, my panel. Thank you for being short. We are 3 minutes late.
Thank you.
Kia ora and hello. My name is Gehan Gunasekara. I'm an associate professor in commercial law at the University of Auckland Business School. And I'm very happy today to be talking to you on the topic of whether it's possible to give legal personality to inanimate objects. And the case study that I have chosen for you is one from my own country, from Aotearoa, New Zealand, where a river in 2017 was given legal status in law as a separate legal entity. Since then, there have been many other precedents of mountains and other objects being given legal entity status, but I believe this was the very first one. And the picture to your right is in the city of Wanganui, where the river flows to the sea, which is also where I grew up. Now, the question that I want to discuss with you today is, could we do the same for data? If a river can have separate legal personality, why not data? Why not personal data, especially aggregated personal data? If we were to use the river legislation as a model, we'll see that it has several key features. One of them is 4 fundamental values that everyone dealing with the entity has to show that they comply with. All stakeholders need to show that they are complying with these 4 values. They need to be documented, and those human stewards who are acting in the interest of their entity need to show that they are complying with these 4 values. Could we do the same for a data entity? Could we have some fundamental values that need to be adhered to? In the case of the river, what are these 4 values? The first one is the river is a spiritual and physical entity giving sustenance. In other words, it's not just a physical thing, an object, it also has a metaphysical, a spiritual element. Now, you might think it's not too far-fetched to think we could say the same for data. After all, people have a fascination nowadays with ancestry databases. People want to reconnect with long dead relatives. Surely there is a spiritual or metaphysical element to that as well. With the river, the river is mandated to give sustenance to the people that are meant to be its stakeholders. Could we say the same for data? Could any data entity be required to give sustenance to humans? In the case of the river, of course, there have been many successful examples where sustenance, environmental goals, jobs have been created. So the entity has been a force for good. The second value is that the river is an indivisible and living whole from the mountains to the sea. In other words, there is an interconnectedness in the concept of the river. In the same way, we could say data is interconnected. DNA being the most obvious manifestation of that. The concept of a flow with data portability is another. The third value is the river is me and I am the river. In other words, any assault on one aspect affects the whole. Could we say the same for a data breach? Even if somebody's data is not compromised, but there has been a data breach, the data as a whole has surely been compromised. Applications of that in the aggregate area are very obvious. So even if data is anonymized and aggregated, it can still be misused. Consider the very famous example of the Havasupai Indian DNA samples, where researchers had got permission to use the data for diabetes research, but instead they used it to research mental health, a gross violation of trust. The final value in the river legislation is there is a collaborative aspect. Small and large streams form one body. In other words, the whole purpose of the undertaking is collaboration and engagement. There must be a common purpose or a vision. Surely the same can apply to any future data entity. And I think data entities would be a vehicle for aggregating personal information and needs to be given serious consideration. Thank you for listening.
Me in thanking our fantastic moderator and speakers from our previous panel. Our final panel today and the GPA Open Session program is a call to action and will be moderated by Mr. White. Often, privacy is framed in the context of counterbalances, and we have been told we must choose between privacy or technological awareness or national security or any number of other laudable goals. But this is a false dichotomy. The solution is not to choose privacy or something else, but to develop a strategy for privacy and. Without further ado, Mr. White, please begin when you're ready. Thank you.
There you go. Good afternoon, everyone. So in Bermuda, I'm not allowed to continue with the presentation until you say good afternoon back. That's a rule here. So let's try it again. Good afternoon, everyone. Thank you very much. Thanks for indulging us with that. Very excited to have this illustrious panel up on stage with me today. This session is called A Call to Action. And the reason for that is we want to take a lot of the things that we've talked about this week and discuss how we can put those into practical terms, how we can make them happen. What are things that we can do actively right now in order to bring these things into effect? And I discovered earlier this week that Malcolm on the end and I are both big jazz fans. And so with that in mind, this is going to be kind of a jazz-inspired session, particularly if you know anything about jazz, so Dave Brubeck and bebop and things like that. The idea being that you get a very talented group of people together and everyone makes their own riffs Everyone takes one thread and adds to it, changes it, passes it along to the next person. So I'm hoping that we can take the motifs that have come out throughout this entire open session and weave them together in some coherent way. And if it can be harmonic, that would be even better.
Yeah, it's quite noisy.
So with that in mind, let's start by introducing our panel. And so on the far end, we have Malcolm Crompton, who is the founder and partner of IIS Partners, who gets bonus points for adopting the local attire while he was here. Then we have Teki Akueta, founder and executive director of the African Digital Rights Hub. And then we get to the alphabetically challenged section where we're very heavy on the end of the alphabet for everyone else. So next we have Wojciech Wiewiórowski, the European Data Protection Supervisor, Eduardo Usteran, partner at Hogan Lovells, Zikin Young, Chief Executive at the Singapore Academy of Law, and Dr. Gabriela Zanfir Fortuna, Vice President for Global Privacy at the Future of Privacy Forum. So our first thread that we wanted to pick up and try to have a conversation about was the idea that's come up a couple of times throughout this event, and that's the question of harm and how we should be thinking about privacy harms. Do DPAs focus on privacy harms enough? And so I warned you in advance that I was going to be doing this, but so I'm going to throw it to you first, Zeke. How do you think DPAs should be incorporating harm more into what they're doing?
Well, I think that DPAs already do incorporate harms into what they're doing. We deal with it in kind of like, well, I used to deal with it in one of two aspects, right? How do you prevent, right? And in the case where you are actually investigating, how do you actually identify the harm, the severity, and the impact of the harm? So that's something that we've done. So I think that let's start with this, right? How can you prevent harm? And I think that as DPAs with data in our title, right, we can take a very data-driven approach. We've seen enough cases, right? Prevention is better than cure. Through the cases that we've seen, it is very, very possible to distill the problems that cause harm, the issues that companies are struggling with. And once you have distilled them, you can actually put them into very user-friendly guides, which are especially helpful for small and medium businesses. For example, we had distilled one whole bunch of problems with IT systems. Put out a guide to say that if you do own and run an IT system, here are things that you can do that will prevent, that will help you avoid getting into problems. We also come across situations where there are process failures, there are mistakes. Again, distill that into a checklist, right? For small and medium-sized businesses, here are things that you can do, right? And if you did them, you will actually avoid getting into situations. It will prevent harm being caused to data subjects. The other thing that I think we can do is also to incentivize, right, good practices. Now, how do you go about doing that? Right? I think you can do it in two ways. One is that you recognize good practices by through enforcement policies, right? And what do I mean? We were fortunate, we were able to introduce in our legislation the option of a statutory undertaking. So basically, if you've got good practices in place, you've got a good system in place, you are able to detect those breaches proactively, come notify us, you had a drawer plans, your breach management plan in place, it is possible for us to basically give you the time that you need to implement those plans without commencing enforcement action. So that's one way where you can incentivize good behavior. And because you have these measures in place, it will help reduce harm because you're better able to react and remediate much more quickly. Even in the situations where we don't accept an undertaking and we ended up investigating, you can take these good practices into account as good mitigating factor, and that can actually be reflected in a lower sentence. And I think one of the things that's often overlooked, right, is that in situations where after investigating and you see that there hasn't been a breach, identifying the good practices that had been in place and acknowledging them, right, that also sends a message. I'll end off with this last point, right? The other thing that's going to be very helpful is to work with companies with good practices and showcase these good practices. How do you lift up and identify good role models? Because for businesses, it's easier to see good practices and emulate them than to be told what to do, right? So how can you do that? Well, there are a couple of ways, right? One, one of the things that we learned is that you have to be very specific when you identify role models. So it has to be a very focused event. So we've done one, for example, there was a period when we were strengthening and tightening our policies around the collection and use of national identifiers. And we were pushing companies to try and adopt digital solutions that were privacy preserving. So identify a bunch of companies that did these, right? Showcase them, put out short videos, others saw, and then they could follow. There are other situations where part of our efforts to push AI governance, we had 2 volumes of a compendium of use cases identifying companies who were prepared to showcase their practices, and it created that, I would say, momentum, right? The more you see that your neighbor is able to do it, and they did it this way, then it's easier for you to adopt these practices. By promoting these good practices, it is going to be very helpful for us to prevent harm.
So, and let me follow up on that last point, because it's such a great point. A lot of times when I talk to businesses, I talk to one that's doing a great job, and I say, you're doing a great job. Can we do a webinar or something? I want to show the community this is possible. Look at this person who's doing the right thing. Right. And they always say no. They say, no, I don't want the spotlight. I don't want attention. How do you overcome that?
The honest truth is you won't be able to convince everyone. Yeah. So for every one company that we managed to convince to be part of this showcase, we probably had to talk to another 3 or 4 more who basically said, no, I don't want that attention. I don't want a situation where I'm showcased this year, but 2 years later, I'm involved in an incident. Right? They want to avoid that. But I'll flip it the other way around. It's not to say that none of the companies that we have showcased have ever gotten into trouble later on. There have been 1 or 2 who did, right? Because you just cannot prevent some of these things from happening, even with the best of practices and measures in place. But what we did realize is when that happens, and a company who had been showcased before, right, who for example had a trust mark before, they tended to react very quickly. They tended to be very, very earnest in trying to remediate because they do not want to disappoint both their own board, their customers, the regulator. So it's that actually it's a good thing that can come out of it. Mm-hmm.
Any other thoughts? Riffs on that? Okay.
Yeah, I can quickly add something about harms. And I think as a community, we will be forced more and more to think about harms, to categorize them, to actually think of frameworks where we can define various kinds of harms. And I'm saying that because, as you've seen in all of our conversations in these past 2 days, the development of AI systems, of very sophisticated algorithms, of automated decision-making, are pushing this nice amorphous, in a way, concept that we've been playing around with harm into very, very concrete sort of consequences for individuals, for societies, for community. And I think that as lawyers, we always love to say it depends when we're looking at a case. And then in data protection law particularly, we always have it's a case-by-case basis analysis. It really depends on each case. However, I think we can come together as a community again and at least create a bit of a framework around what type of harms we should be looking at. Also considering that we have increasingly a new generation of legislation like the Digital Services Act in the European Union, which is looking at systemic harms in recommender systems and the algorithms that are used by recommender systems. So I think we have a role to play there in trying to define the type of harms, categorizing them a bit, and paying attention to that. And we tried to do that some years ago at the Future of Privacy Forum. We have a chart, harms by algorithm, published around 2017. And I think it's about time for us to update that. But something to that extent should be helpful for the community.
Yeah, I was going to plug that if you didn't, because it's been very helpful in explaining to the community what's the point of all of this. Wojciech.
But I would be at the same time a little bit cautious with dealing with harm as the main assessment goal. Because if the goal is to find the harm and find the compensation for that, then the answer is civil law and the torts. And probably the data protection world is not necessary because we can somehow do it with the classic law. But I guess one of the reasons for which the data protection regime has differentiated from the privacy in the civil meaning of this word is that sometimes it's extremely difficult to show the precise harm that happens to precise person that will be compensated, or the harm is not as shocking to the public as it may be actually to the final situation of the person. Well, if our information on our badges here at the conference would include the information about our political views and about our religious beliefs, it would not any harm to us, but it will be absolutely nonsense from the data protection point of view. These are the sensitive data for which there is absolutely no need to be presented. So the processing of the data does not need to be harmful in order not to be needed.
Mm-hmm. Great point. Eduardo.
Yeah, I think, to your point, the way I understand harm has been debated by this panel is in the widest possible sense of the word, so that it accommodates the Anglo-Saxon side, the European side. And I think from a European side, my experience, my perspective is that harm in that wider sense is definitely something that is being considered. And when you look at probably one of the most basic data protection law obligations, which is to have a lawful basis for the processing. And when we apply the most commonly applied lawful basis, which is legitimate interest, that is basically a harm calculation as to whether the processing of personal data is going to harm or is going to lead to a privacy intrusion that is intolerable. So I think that exists. But can I say something a little bit more controversial, perhaps? I think we are overdoing harm. I think, by all means, harms need to be taken into account. By all means, harms are a dimension of all of our work in terms of making sure that whatever we allow to do or we contribute to do doesn't cause harm. But when you focus on harm, the best thing almost the best result is to avoid the harm, so that you basically end up where you started. The question from the point of view, I think, from a regulator and from all of us as professionals is not just how to avoid harm, but how to contribute something positive. And that something positive may be how to allow people to be more in control of the data, or how to ensure that there is greater value to the use of that data in a way that not only is not harmful, but is actually positive to the individual, to the community, to the world at large. So I think it's just the reason I'm flagging this is that there is this quite obsession with harm and avoiding harm, and that could lead to basically a zero-sum game where, in fact, we're not really positively contributing to the benefit of the individuals and the population.
Yeah, Kazik?
Yeah, I like to kind of challenge and push back on that, right? Because I think that instinctively, we do incorporate severity of harm into our analysis. And look, what's Wojciech and your intervention has got me thinking is that actually there's presumed harm and there is provable harm. If you can prove the harm is physical injury, unlikely to happen, financial loss, yes, you can have a civil suit, you can pursue that. A lot of what, and in those situations, there can be situations where, as a regulator, you can also investigate. Then there is presumed harm, right? Where the mere loss of data is presumed to cause some degree of harm. The mere failure of putting in place a good accountable system is going to expose you to a certain level of harm. But we need to basically articulate, right, what we are looking at when we look at this harm. It's really the likelihood of it happening and the impact of it on an individual. Because once we're able to identify this, it helps us calibrate our enforcement response and also our analysis, right, of whether, when we do our impact assessment, it helps us calibrate that. And if we're able to do that well, we can actually say that allow certain processing to carry on, right? Or in a case of a breach, right, where it is a lower degree of harm, less impact, we might be able to consider other enforcement results that might be directions and rehabilitative as opposed to punitive and financial penalties. So I think that if you're able to actually develop a framework, it's going to be helpful. And I can say that at least when I was looking at these areas, it was actually something that we did consider.
I just want to clarify in an answer to Wojciech's points, to clarify where my comment came from. And I said at the very beginning that we will be forced to think more and more on harms as a community, particularly because in classical data protection law, harms frankly do not play such big of a role. We do have compensation for damages when they happen, of course, and that's a part of it. And then now with the GDPR and the laws afterwards, data protection impact assessments where harms can play a role. But I was primarily thinking about where the technology is going with frankly, everything that's happening around algorithms, automated decision-making, and so forth, and the stage of all of this where we are at right now. And this is what makes me think we will be forced to think a bit more and more about harms also to communities. And I'm sure we'll get to that point later on in our conversation.
Whenever we're ready, it's good.
But absolutely, fully agree with your view, Wojciech, on this.
Techie, did I detect you wanted to jump in?
Yes, I wanted to. I mean, in one breath, I really agreed with Eduardo on the balance aspect. But then again, thinking and having worked in Africa and working there a lot, I'm just thinking about probably looking at the harm approach may also be a useful approach for DPAs, particularly from developing economies. The reason I'm saying that is because usually these DPAs become leaders in the data protection ecosystem with very limited resources to roll out compliance and all of that. And so without a perspective of looking at these issues from the harm perspective, so if, let's say, your country is rolling out a national ID system, or there's a new technology that is being adopted, having that ability and the capability to look at it from the harm perspective will also enable you categorize or prioritize which areas you should focus on based on the higher risk areas. So I also see the issue of the harm approach as a way to actually enable us apply limited resources to areas that is quite useful. And that's just what I wanted to add to this at this point.
Great, Malcolm.
Particularly this morning, I was listening to the conversation about the word harm and the conversation about the word risk, and I don't think we've properly put the two things together, because a harm is when information about me is stolen and that something nasty happens because of that. Somebody might be able to steal money from me because of it, or I lose my job, or whatever is the harm. Risk, as we've said many times today, is about probability of the nasty event happening and the impact of that nasty event happening. And that second thing, the impact, is potentially the harm. Now, risk is actually best thought about in the sense of the trilogy of risk management: prevent, detect, respond. And what you're trying to do in risk management is do as much prevention as you can, but not elimination, because elimination is chasing the tail of a long curve down to infinity dollars. So there will always be some exposure, but prevent is getting prevent right. You can't possibly remediate if you haven't got a detection process. So that's why it's prevent, detect, respond. Prevent is mostly about reducing the likelihood, and respond is mostly about reducing the impact of the harm when it happens. One of the interesting things that doesn't come up often enough is that there's two categories of harm: the non-reversible harm and the reversible harm. If you're dead, you're dead. And that's why you put a lot of effort into making sure those kinds of harms don't happen.
Yeah.
On the other hand, if it's a reversible harm with sufficient funding, resource, effort, you can actually reverse almost anything. Supposing what happens is early in your life, your reputation is so ruined that you're unemployable for the rest of your life because the bad story about you that might actually be wrong follows you everywhere. Or there's identity takeover, which is just follows you everywhere, that you're no longer ever able to get credit, you're no longer ever able to get work, blah, blah, blah. Think of the money that could be paid to that person to have them say, thank you very much. It is a finite sum of money. It might be $100 million, but that figure exists. But you can only apply that thinking if the harm is reversible. And if the doctor chops off the wrong leg in the surgery, that's still a non-reversible harm. It's not just if you're dead, you're dead. There are a whole series of non-reversible harms. So when you're thinking about analysing for these things, first of all, you have to think about reversible harm versus non-reversible harm. Really, when you're talking about risk management, you're trying to decide if effectively and almost cynically what's an acceptable level of bad things happening in terms of a frequency. But also you're thinking about, in terms of the risk management, is there a way of reducing the impact of the harm should it happen at a probabilistic level or a societal level or a community level? So, for example, if, say, you've got an identity management system in place or your identity card is compromised, and you then have to spend weeks standing in a queue to re-identify yourself. You have to pay a lot of money to get new cards. You have to go and stand in another set of queues to deal with the bank to get your bank accounts done and all that sort of stuff. That's a huge harm. But you can actually anticipate that and have wonderful harm management processes such that even though the event happens, its impact is a lot less. Those are all about risk management. But to bring it back to harm, that is when it comes down to the personal. And that's why it's so hard to manage for harm in the world of privacy. Because if somebody is living in an abusive relationship and they choose to flee home, their address is potentially lethal information. They may die because the abusing partner is able to catch them at the new address and kill them. Most of us in this room probably aren't going to suffer a harm as nasty as that in our lifetimes, It may be just a nuisance, or somebody puts a bomb in your letterbox and it goes off, or somebody steals a couple of letters out of your letterbox, or whatever it is, but it's not going to be that bad. The problem is, as you're managing for these harms, you don't know which it is. That is why, both as a DPA or a DPO, you have to be aware that you can't deal in the averages thinking that happens with risk management. You actually have to get down to the personal, and that's why harm has to be thought about not just within the risk management context. Risk management helps you get a lot of the probabilities and the impacts down, but still it could lead to an extreme harm in a circumstance that you haven't predicted, which is why it's so difficult. But I do think it's very important that we think about, when we're talking about risk and we're talking about harm, we're not necessarily talking about the same thing, but they are very tightly integrated in how you're thinking about managing for it all. And I don't think that we'd quite reached that point in the discussion today.
I think that's a great point. I'm so glad you brought that up. And I also wanted to touch back on something Eduardo said when you were talking about not just preventing harm, but also enabling. And I think this gets wrapped up into the privacy principle of fairness even, because we could say, well, is fairness to act in someone's best interest, or just act in a way that is not against their interest, or is it to prevent harm, or what have you? And so I wonder, should DPAs be putting affirmative duties on organizations to make someone's life better with however they process their data? Should there be an affirmative duty? I'll start with you, Eduardo. What do you think?
Well,
me.
If we have a volunteer, we'll take a volunteer.
You asked me to tell DPS how to do their job better. Excellent. I think the answer is yes. I would like to think that anyone in any job in this field goes to work thinking, okay, what can I do to make other people's lives better? Or maybe not like that, thinking every single second, but in a way, trying to contribute something positive to it. And I think the world of data, I think, needs to be understood, in my view, in the wider context of how we operate today. And we live in a data world, and we, as individuals, there is so much of us that is out there as our data. And the question is, how can all of this information benefit us as individuals, and then, again, the population and humanity at large? And how the processing of this information contributes to that. And I think that has to be embedded in that thinking, in that risk assessment, and in that judgment about harms. And I'm not saying it's easy, but I think it's the right thing to do.
Wojciech? No? Okay, take it.
Yeah, I was going to say that if you look at the context of data protection law in totality, it's about fairness, right? And so where the regulators then have the responsibility to ensure compliance with the law, then that is their job, to ensure that fairness. What are you going to say?
I'm usually very cautious once again with fairness. Fairness is a principle which in English language have its own meaning. And we speak English mainly here at the conference, so we think that we know what we are talking about. So I have the kind of homework for those who know more languages. Just go on to Article 5 of GDPR, where there is a principle of legality, fairness, and transparency. And check in all the languages that you know, and which are the European languages, what are the translations of fairness to the other languages. You will be surprised by the German one. You will be surprised how the Portuguese is different from the French and Spanish. You will be surprised by the difference between Slovak and Czech, despite the languages are almost the same. Yeah? So we have completely different thing in mind when we think about fairness that we are talking about here. So that is something to be taken into consideration. But I fully agree that the role of the data protection commissioners is to make the life better, with all the problems with assessing what it means in the everyday work of the data protection commissioner. But you can be sure that when I'm leaving home, I'm going to work, and I know that I'm going to work for the good of the society.
Phew. So, well, thank you all so much. This was we're one question in, so this was really great. But the kind of 1B of this question was thinking, okay, well, how do we take everything we just talked about and ask, is there a difference between how we handle these things as legacy technology issues and how we handle these things as emerging technology issues? Who wants to go first? I didn't pick anyone for this. Gabriella, you're poised.
I feel like I already touched a bit on this when I was speaking earlier about how the new technologies force us in data protection law to start thinking more about harms. And I think that that is exactly the case. We are at the stage where the development of AI is at this point where, and all sorts of other algorithmic decision-making systems that are used by social security services to decide who gets a benefit or not, and so forth. We are at this stage where we need to think in a very structured way about harms and just not let this concept just floating around without some meat on the bones. That's my opinion.
Thank you.
Yeah, maybe my thoughts on this is that with new technology, there is the what you know and what you don't know, right? This comes from past discussions through our regulatory sandbox with industry and all that. Usually, by the time they come and engage the regulator, they've done a bit of homework. They've tried to identify what they think might happen, harm, right, that might be caused. They don't come with totally unprepared. They come with some preparation. And with that preparation, it's a lot easier in that discussion to really build on it and to really understand, yes, I understand that this is what you think might happen. And in the iteration, sometimes we discover new articulations. Sometimes, we don't, right? But that's helpful because at least we are taking a step at identifying. And then once you're able to identify, the follow-on steps, as we heard earlier, is that you're better able to manage the risk, the likelihood of that happening, right? And if it does happen, then you can have measures to remediate. But then, of course, there are those situations where, as we know, the technology goes out in the market, the identifiable, the known risks have been addressed, but a year, 2 years, 5 years later, a new set of harm emerges. Well, I don't know how to deal with that, right? Yeah, it will happen. So I guess perhaps constant monitoring, but I don't have any answer for that.
I'm a big believer in technological neutrality in this context, in the sense that there is no other way to regulate properly in this area other than being technologically neutral. Because if you tried to regulate a particular type of technology, you just can't catch up, And I mean, we're in Bermuda. We are about to, in the next few months, PIPA will become law here. The process of development of PIPA has taken years. And I was part of that process. And at the very beginning of that process, the team that was involved, we thought that this had to be a very progressive law. It had to be a law that was prepared to deal with the challenges of the future. We weren't thinking of generative AI as we know it today. We weren't thinking of facial recognition with biometrics and in public spaces as we know it today. But we thought that it had to address the challenges of whatever technology existed then and in the future. So I think from that perspective, law cannot play catch up with technology. But what law can do is adapt itself to technology as technology evolves. And I would like to think that privacy law or data protection law, as we call it in Europe, is actually very agile when you look at it, at being able to adapt to technological developments. Because some of these principles we've been talking, and I'm not saying that law is perfect, but some of these principles we're talking about have existed for 30 years or longer. And they still apply today. The question is how you apply them today. Because if the outcome of applying a particular principle that was drafted 30 years ago is to say, I'm really sorry, we cannot have artificial intelligence anymore. No, it was a good idea, but we cannot do it because this principle is telling us that it's unlawful. I can tell you, first, that's not going to happen from a practical perspective because someone will develop artificial intelligence anyway. But at a more profound level, it's likely to be the wrong outcome. It may not, I'm not saying that the process of developing artificial intelligence does not need to take into account all the privacy elements and data protection compliance requirements within the law. But the law needs to be interpreted in a way that is cognizant of what is actually happening in the real world and able to achieve the right outcomes as opposed to pulling the plug on a technology or pulling the plug on the internet when that is not going to really be beneficial for the vast majority of people.
I would absolutely agree with Eduardo, thinking that the principles that exist in the privacy and data protection law are to be used for the new technologies the same way as they were for the past technologies, and the technological neutrality is important. We heard about it in the one of the first panels when we heard the American and European approach saying we have the law that is applying to artificial intelligence. Probably we have some gaps. Let's talk about the gaps. But generally the law is, and it should be applied from the very first day. I agree that sometimes we may find the new challenges that we didn't have so far. For example, in my opinion, part of the blockchain solutions create the problem of the processor and controller between the miner and the rest of the world, let's say, because it's hard to put the miner into the concept of controller processor. That's something to be discussed, yes. But generally, there is nothing that stopped to use the principles which exist in the world to the new technologies.
All right, thank you. So, well, then let's turn to question number 2. I loved question number 1. I was very excited about question number 1. So question number 2 is we've talked about something throughout the last few days, and the first component to this question is something we all agree on, which is that data is everywhere. It's involved in everything we do. We all have to have data. But data protection authorities cannot do everything. They cannot be everywhere all at once. So what we need is to figure out how can regulators of data protection work with regulators in other areas who are looking at those matters. And that's something we wanted to bring out in this conversation over the last few days. So Malcolm, I wanted to start with you. What do you think data protection regulators can bring in from other types of regulators?
Thank you. I've been giving a lot of thought to this question since you posed it to me before, and I'm actually going to approach it from probably 3 dimensions. One of them is what have other regulators done that we can learn? Another one is what have other data protection regulators done that others of us can learn? And the other one is there some useful academic thinking? And I'm going to say that I'm about to give you almost fast food answers that hopefully are implementable tomorrow kind of answers for the people here who are from the data protection authorities. So it is 20 years ago today, to use a Beatles song, when we held a conference like this in Sydney. It was GPA 25. And one of the speakers was a gentleman called Alan Fells. Alan Fels was the most effective regulator in Australia at the time. He ran the Australian Competition and Consumer Commission, which is a similar beast to the US Federal Trade Commission. And then there's John Braithwaite and the Braithwaite and Ayres responsive regulation thinking. And there's Malcolm Sparrow and the regulatory craft. And then there are things like the Federal Trade Commission, which has had to craft out of nothing a silk purse out of the sow's ear of Section 5 of the Federal Trade Commission Act. Now, maybe the people in the Federal Trade Commission don't want to be called a sow's pig's thingamy-bob, but they have made remarkable progress in creating something out of Section 5 of the Federal Trade Commission Act. What are the lessons that I think come from that bag of sources? One of the things that Alan Fels said at the 2003 conference was you have to think as a regulator about your authorising environment, of which the law is only a component. And he talked about the formal and informal sources of authority. And he said publicity and engagement as a tool for education, enforcement and accountability is important. Some may suggest that a regulator should simply enforce the law and no more. They should carry out the will of the Parliament. I would argue, however, that this is not sufficient, especially in circumstances where there is significant uncertainty like privacy protection. That uncertainty will continue forever because it's the nature of the beast. It's just the nature of the beast. Responsive regulation was all about if you can persuade people with reasonable persuasion to be good boys and girls, that's a good thing. But if they're stepping out of line, they're going to get the warning. And if the warning's not good enough, you're about to knock on their door. And if that's not good enough, you're about to start whacking fines on them. And if that's not good enough, you're going to see them in court and take them to jail. But the whole idea of responsive regulation is that the expense to everybody of going higher up that pyramid increases. And what you're therefore going to do is by the behaviour of the regulator, everybody gets encouraged to go back down to the bottom. It's cheaper for them and it's cheaper for the regulator. But the process of responsive regulation was invented decades ago now and is still worth coming back to as a regulator. Malcolm Sparrow's regulatory craft is often quoted with a single sentence, but there's actually two important sentences in there. One of them is, pick important problems and fix them. There's nothing like being a successful regulator in the eyes of a whole lot of people if you've actually picked on something and fixed it. But the other part of what he said was, and then tell everybody. There's a huge educational component, a multiplier in having been successful. And when you're successful, you're therefore given social licence to be successful again and be more adventurous. And that's what Alan Fels did extraordinarily well by being repeatedly successful. And I think we've got some other regulators in the room who've done similarly well. What I found really interesting about the commentary by the Federal Trade Commission yesterday was the way, in particular, they've gone about strategic precedent setting. In an economy the size of the USA, with the Federal Trade Commission the size of the Federal Trade Commission, they can't do everything. They're as resource constrained as the Commissioner here in Bermuda or all the people in the Caribbean that we heard about yesterday. In a comparative sense, they're just as resource constrained. I'm going to be extremely rude to John Edwards and Elizabeth Denham and people like that and say, you're the best resource privacy regulator in the world. You're different from the rest of us. Most of us have been extremely resource constrained, so you have to be very strategic in what you do. You try and set maximum precedent with minimum effort, get a multiplier. When I was the Privacy Commissioner, we set up a process of every time we handled a complaint, how did we multiply the sound of that complaint? That's why we set up the process of publishing little screeds, two-page screeds about each of the important complaints that we'd resolved so that the rest of the world knew how we were thinking. We were trying to take a complaint from being one person made better to many people learning a lesson by just a little bit more effort. So I think that we need to go about it as a regulator remembering the three mandates that you have. The first mandate is the law. And the law does three things, not two, not one, three things. One, it tells you as the regulator what you must do. It can tell you as the regulator what you must not do. And then there's a huge grey area in between. occupy the grey area. And one of those things is this business of using your voice. When I was the Privacy Commissioner, my total budget for getting the privacy law in Australia that was about to be applied to the rest of Australia into the public domain, I had $50,000. That was one full-page advertisement.
That's a lot.
The most important advertising I had was my jawbone. I grabbed every microphone I could possibly see and spoke into it. I held enough meetings to say I spoke to 10,000 faces in a year by going all over Australia and talking. If you think about advertising, when you're talking in the middle of a news bulletin, what you say is vastly more credible and heard than the same words said as an advertisement, a paid advertisement somewhere else in the program. Get into the news. A data breach is gold, but it doesn't have to be just a data breach. There's a whole lot of other things where you can draw lessons and have people think. That is part of the middle mandate, the grey area. Nobody tells you you can't do it. Nobody tells you that you must do it. But you can do it. And it is possibly the most important part of your remit. But that leads to the other two mandates. One of them is the funding, and we've discussed the funding a lot. And I'd have to say, when we come up to a lot of the privacy law reform we're doing in Australia, for example, I don't care. Because if they don't give the privacy regulator enough money to do the job, it doesn't matter what the law says. People will ignore it anyway. So that's your second mandate. What funding have you got? And your third mandate is the social licence. And that pick a small problem and fix it is part of increasing your social licence, your credibility with three interest groups: the government, the people who write your cheque; the media, who will promptly take you down if they possibly can, but will actually be a great ally if you can give them a great story. One of the early things that Elizabeth did, blush, 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 was she printed T-shirts. And when they did some door knocking to be very visible with some of their enforcement and inquiry actions, they were wearing T-shirts that basically made sure everybody knew where they were from. It was a really seriously good idea to make sure that they got some positive publicity in what they were doing. And the third one is just the general public. You need to think about how you bring everybody along with you. That will be your most potent weapon. And then the last one that I think came out very, very well from particularly the Federal Trade Commission is the enforcement muscle. I haven't heard that one before. Yeah, strengthen your enforcement muscle was really quite good. But the other point that they made, and I wonder how applicable it is more widely than in just the USFTC context, is we spend so much time talking about fines. My fines are bigger than your fines, or whatever it is. And remember, USFTC in a single fine has charged more in the way of fines than all of the other regulators around the world put together over time. So, but then they said the most effective punishment is to require the data to be deleted, the algorithms applying to that data to be destroyed, and all the inferences drawn from that data to be also deleted and destroyed. You're taking away the future source of revenue. That will be even more punishment than the fines. I rather like that, which I'd thought of it. Anyway, and the last one I want to talk to about the regulators is literally yourself. It's a very lonely job sometimes, very lonely. Even your staff won't understand always what you're experiencing, let alone family, let alone other people. You actually have to recognise that it can be a very lonely job, and you have to be very strong in yourself in the job, and you have to have some ways of sometimes giving yourself space. If you're not thinking about yourself as a person, you're going to possibly find it very difficult. The other point that I'd make about yourself is end of term. It's literally in the space of a minute. You move from being rooster today to feather duster tomorrow. Okay, think about it. Because it's, I could feel the power going to my head while I was the regulator, and then I had to walk out the door and be Mr. Johnny Nobody. And that's quite a psychological impact. And if you haven't thought about it before you're out of the job, when it happens when you leave the job, it's too late. And the beautiful thing about being a regulator is you know the day you're going to be sacked 3 years to 5 years to 7 years in advance. You've got some dime guys to prepare for it, but don't do it on the day. Okay, two more. After I'd finished as the Privacy Commissioner, I met somebody else who'd recently finished in another regulator's job in Australia, happened to be ACCC again, and she and I were having a bit of a wine, as in W-I-N-E, at a company directors conference, and she said to me, because I've been through this experience, she said, Malcolm, when you finish off in a job like that, it's the best love affair you've ever had, and you're on the rebound. That means you're about to make mistakes. Don't pick up somebody while you're on the rebound. You have to be really careful when you're on the rebound. And it's the same thing about what job you do next or where you go to next. You can actually be slightly fragile when you've finished in doing the most wonderful job you've ever had in your career to suddenly being a nobody. Think about all of these things as you're doing the job so that you can do the job better. And the last one is what happens as a consequence of everything that I've said? Disappear. The press will want you to be a critic of your replacement, to be commenting on your replacement. It's the worst thing you can do to the person who's taken your job. You literally have to go from being a loud, noisy, propagating person up to the end of your term, and then you have to disappear. That requires discipline too. So I just felt that if we were talking about how to be a good regulator, and part of the element of being a good regulator is self-management. And I thought it was something worth putting into the ring in addition to everything else you were asking me about.
Thank you. And Techie, did I see?
Yeah, I mean, those are very, very interesting comments, some of which I have relived through. But I wanted to really touch on your initial question, which was around how do you work with other regulators. And I just want to draw on my experience. In fact, when I was setting up Ghana's, that was an extremely difficult, but it turned out to be one of the best relationships to build. And it was very deliberate, one, because we did not have all the resources. And so as a new regulator that was coming on board, you did not also have the respect of the industry that you are seeking to get. And so you needed what I call the relationship that could build that respect. I remember one of our initial approaches was to reach out to the central bank. And then we had a requirement to register, and nobody was minding us, nobody. And I couldn't blame them. We were locked up in some tiny office, you know, in the government ministry where everybody was asking, what are you supposed to, are you sure you can implement any of these laws in Ghana? So reaching out to the central bank at the time was extremely helpful. And within a short period of getting the central bank and its board to appreciate the fact that, you know, the registration was important and our work equally complemented the work that they did, within a very short time, we had the, you know, whole financial sector, you know, queuing up to do what we wanted them to do without much difficulty. We did the same thing with the communications regulator, and we were then working on and on. So building that relationship is extremely important. In Ghana's case as well, we had actually thought about this when we're developing the law. So also on our board, so we did not just have a commissioner, we had a board that constituted the commission, of which we had a head, that was the executive director that did the day-to-day implementation. On the board, we actually had the central bank there. We had the National IT Agency, which is government's big IT authority, also sitting on the board, and then also the communications regulator, and even industry associations rep were on our board. So all these really helped build very strategic relationships. And I love what you said about the media, because I think you having $50,000 was a lot. We had nothing. I think one of our first videos that is still somewhere on the YouTube, I had to become an actor, you know, invariably, and my whole staff, everybody was in the video because we had to. I remember I became a script writer by force because of the resources that we have. But we had to be very ingenious. And one of the things that we created, we created what we call the press corps. And what was all that? We picked a bunch of media people, put them in a room, trained them, and made them feel special, right? And made them understand the data protection issues. So these people were at our beck and call anytime there was something publicly out there that had a hint of data protection. And we really jumped on that to raise awareness with the limited resources that we have, yes.
You just raised one thing that I was going to just embellish a little bit more. Your engagement of the other regulators, the way I did it was actually I struck memorandums of understanding with about 5 or 6 of the regulators, because one of the things business hates is more than one regulator knocking on the door on the same problem.
Yeah.
And so I struck MOUs with the communications authorities, with the ACCC because of competition and consumer protection law, and 2 or 3 others. And it was a way of knocking on the door and saying, hiya, I'm the new kid on the block, at the same time as actually straightening out who was going to do what as a way of getting things done. So it formalised a bit of what you're saying.
And in our case as well, because there were so many regulators, we were already having the challenge of, you know, government was already being bombarded with coming up with all these regulators knocking on our doors and harassing us, and we can't breathe as businesses. So having that was also a way of trying to collaborate to really say we're listening also to the public, yes.
Brilliant.
Yeah, and we're seeing those sorts of formal relationships a lot more with models like the Digital Regulators Cooperation Forum in the UK, and so I'd be curious to get people's thoughts on those types of models too, but I know you had said you wanted to intervene too, Zeke.
Yeah, so I thought I'll share some thoughts about why regulators should collaborate, and less about how, because I think different cultures, different countries, right? I wouldn't ever propose a memorandum of understanding with a fellow regulator in Singapore. They give me a funny look because it's a small place. We call each other, we sit down, and we have a discussion, right? So, yeah, so it really depends, right, on culture and the country. But I'll talk about why it is important in the sense that you can look at it as there are situations when you need to have cooperation because something happens and multiple regulators need to be engaged in the enforcement. So there needs to be a method of doing it, as has been observed. In those kind of situations, you can't have too many regulators tripping over each other. We do have a process where we kind of agree that who's going to take the lead, and who else with specific expertise might be able to provide inputs into that investigations. But the more important one, I think, for businesses is actually in situations that don't involve breaches. And this is where, if you put yourself in the shoes of companies, right? And they have a new technology, they have a new issue, right? A new thing has come on. They need to grapple with multiple dimensions. It's got a intellectual property issue, it's got data protection issues, it's got competition issues. And if regulators can come together and work on some of these things, it actually is a very powerful statement to industry that, you know what, we coordinate, we are trying to solve problems. And through my experience, we've actually done that before. So multiple times where we come together, do joint studies. There was a big data issue where competition, intellectual property, and us, we came together and produced a discussion paper identifying the issues, giving our different perspectives. So it's helpful for industry when they're trying to deal with issues like, okay, if I want to get into big data, what do I do? Other situations would be just get, the story behind the AI model framework for Singapore was that it started out where we convened, right? I got all the other regulators together, and basically it started out as simple as, let's come up with a common language, use the terms and use the phrases and have a common understanding of how we're going to use these terms and phrases so that we don't cause confusion to the industry. But one thing led to another, and then in the end, we co-created the model framework. So I think that it is very important for us to also get regulators to come together to deal with some of these emerging tech issues and provide, right, that kind of coordinated point of view. But because that's essentially it, right? It's a point of view at that point in time, but it's helpful.
So I wrote down for my 2024 to-do list, I don't know if this aligns with everybody else, but so we need to define harms in a structured way and set reminders to review that going forward. We need to define risk management while keeping it in the personal context as well. We need to go look up Article 5 of the GDPR in all the languages.
There's actually an excellent paper by Gianclaudio Malgieri that does that for us. It looks...
So now you have no excuse at all. You just go read the paper. So identify the outcomes you want to achieve. How are you going to make people's lives better? Pick an important problem, fix it, and then tell everybody about it. Make sure you do that. And engage with your regulatory colleagues, whether that's a formal arrangement, an MOU, sitting down with a meeting, talking about common definitions for words, anything I've left off the list. Any concluding thoughts from anyone?
I think I would add to the summary the word strategic. It's not just pick a small problem and fix it. It's within the context of where is my small group of people going to have maximum impact. And for example, when I was the commissioner, the arc of the strategy was the social licence didn't exist for a couple of years to actually take a tough enforcement action. There had to be an educational period before you could then say, okay, peoples, time is up, no more excuses, we're going to take you to court or we're going to run a stronger enforcement action. I think the collective mistake that we made in Australia was we were too nice for too long. So we made collectively a strategic mistake. But you do actually have to think about where are you at in time, what is your resourcing available, who are your allies, and actually have some strategic direction in place to do what you're going to do. And in a way, that's the huge difference between being a regulator and a judge. A judge does a case by a case by a case, whereas a regulator has to be much more strategic and seeing the arc of where things are going.
Yeah, I think one thing that I want to add to all is that I agree with you, it's a very lonely place as a regulator to be. I remember when I was setting up Ghana's data protection, probably the only English speaking at the time in West Africa. And so building strategic relationships was extremely important. And I did that both within Africa and to get the experience of other DPAs, and because they had similar experiences to what I was going through. And then I also built outside of Africa. So we had a very unique relationship right from the beginning with the ICO. And I always say that we picked a lot of experiences from there in really helping us build our strategy. And right from the beginning, I remember we actually, Steve, I don't know whether he's around here, we had to formally...
your wave down the back.
Yes, we had to formally get the ICO to bring us someone, because I remember the board, I was the only person sitting on a board of about 12 that only understood data protection. So having him over and talking to the board and helping us develop an initial strategy was extremely helpful. So, and of course, conferences like this was very helpful as well, because I learned a lot by meeting other colleagues and hearing from the experiences. But for me, the conferences were extremely useful to see what, especially when you're looking at the emerging issues where you did not have the resources and the capacity to, grasp all the knowledge there. So yeah, that's just something that I wanted to.
Well, I can finally report firsthand that the flashing red light is very effective. But I'm going to use my prerogative to let everybody say something else if you want. So Eduardo, go for it.
Okay. Well, first of all, I've learned a lot about the role of being a privacy commissioner, so I want to be one because it sounds amazing. No, honestly, it sounds like a very hard job, and I can see why alliances are important. So here's a tip from me. Build alliances from everyone, not just other regulators. Yeah. And again, you know that. But to me, I've been coming to this conference for many years. And one of the good things about this conference is that, I would like to think, it shows to regulators that privacy professionals, whether you are in industry or in a law firm or a consultancy or wherever you are, we are all on the same side. Yeah. We are all involved in this world and in this work because we care about these issues, and we can debate the law, we can debate the practices, what is more efficient, what is more intrusive. But ultimately, I think we can all learn a lot from each other, and I learn a lot from you guys, and I would like to think that there's a contribution that the non-regulators can make to the regulatory community.
Certainly.
Yeah.
One of the things that I did, Eduardo, was particularly when it came to health information, I realised the office and me myself were particularly unskilled in the area of health information. So we set up a health advisory committee, and it was potent. You learn, a person who from the Nurses Federation there, the medical people, the pharmaceutical people, basically a medico-legal kind of person, and you have them around the table for your agenda, and you learn so much. Yeah. And I do think advisory groups have a lot of potential. Yeah. Well said.
Well, unless someone's beating down the door to say one more comment, we'll call it there because we could go all night. But please join me in thanking all of our speakers. So I'm going to have a few more remarks, but thank you very much, everyone. Thank you. So before we go, again, I wanted to take an opportunity to kind of abuse my position at the podium and ask you not to leave just yet, because there's a few people I want to thank. Of course, there's our sponsors in no particular order. Thank you to Merck, Johnson & Johnson, Apple, Google, Meta, TikTok, the Interpublic Group, IAPP, Evolver, CCS Group, ABIR, the Future of Privacy Forum, the Center for Information Policy Leadership, and Bacardi. I wonder if you all have a favorite there, but I'm not going to mention that. And so in addition to that, there's one other thing I need to say, and that's I'm so grateful for my team who's put this together, the team of the Office of the Privacy Commissioner for Bermuda. That throughout all day I've tried to use the line that I'm just shaking hands and everyone else is doing all the work, and that was certainly true. But if you've been involved in any of the preparation at all, you know one name in particular is especially familiar, and that's Kendra Mello. And so everything you see around you, all the fun that you had, is thanks to her. So I do hope you say thanks to her at one point, and I wanted to offer you these, Kendra. Heavier than it was.
I will just say very, very briefly, thank you to all of you for coming. But this is not just me. This is an incredible team that has put this together. And so thank you to all my colleagues in the office and to all of you who have helped with organization.
Okay, so that's not all. Even though that's the end of our formal agenda, we have 2 more side events tonight, one of them conveniently located right here on the main stage. So you have time to run down and grab a coffee and come back, and we'll have a discussion on international action hosted by the European Commission. And then at 5:30, we'll have a discussion on AI and society brought to us by Meta downstairs in the Princess Ballroom. So thank you so much, everyone.
Hi. Hi. We will have 2 Spanish speakers and 1 French speaker. So if you need interpretation services, please go down and find your headsets. Thank you. Welcome to this side event by the European Commission on International Cooperation in Action, the role of the Global Privacy Assembly. The objective of this event is to reflect on the role of the Global Privacy Assembly and the concrete contribution it can give to cooperation in the area of privacy at a time when the GPA is developing its strategic plan for the coming years. To kick off our discussion, there could be nobody better than Alexander White, Privacy Commissioner of Bermuda, and of course, host of Global Privacy Assembly. Welcome to this panel, and congratulations to you and your team on such a great event. The floor is yours.
Thank you very much, Dolores. Very excited about this next discussion because I believe so strongly in this issue. One of the things we had to do when creating this new office for Bermuda was define, well, what is our regulatory philosophy? What are we trying to accomplish? And how do we explain that to the community? And so one of the tools we used was creating what we call the Mid-Atlantic Privacy Compass. And so it's quite literally a compass, and there are different important principles around the compass. And one of them was interoperability / why Bermuda is not an island. And I thought that was a really important message for people to understand, that we are not just someplace far away from everyone else now. Everything that we do online because of modern technology is interconnected. And the English writer John Donne wrote that no man is an island. And that was around the same time that Bermuda was discovered. So I like to think that maybe he was inspired the same way that Shakespeare was inspired by Bermuda to write The Tempest. But just as it was true in those early modern times that no man, no human is an island, no jurisdiction is an island, and it's so important that we all work together. So with that hopefully rousing speech, I'm happy to turn things back to Dolores. Thank you very much.
Poetry.
Thank you, Alex, for these remarks. And before moving to our panel discussion, we are delighted to welcome to the stage, well, who is already seated, to Beatriz Anchorena, Commissioner of the Argentinian DPA, who will give us an overview of GPA's strategic approach through the years. In addition to her role at the Argentinian DPA, Beatriz is member of the GPA Executive Committee, chair of the GPA Strategic Direction Subcommittee, and sponsor of GPA Strategic Plan. Thank you very much for accepting an invitation to deliver a keynote presentation.
Okay, thank you.
That you can do in Spanish.
Yes. Thank you, Dolores. I will speak in Spanish. I just made a panel in English y ahora voy a aprovechar y hablar español. Espero que todos tengan su traductor. Quería agradecer la posibilidad de poner la visión sobre el GPA y sobre la región latinoamericana también. Yo estoy hace 1 año y medio a cargo de la Agencia Autoridad de Protección de Datos de Argentina y si bien el GPA tiene una larga trayectoria, quería dar una visión también de cómo venimos trabajando en el subcomité de dirección estratégica. Y lo primero que se me ocurre compartir con ustedes es que ayer, el domingo, en el primer día de la conferencia, con el panel de las autoridades de protección de datos del Caribe y otros actores, se habló en muchas oportunidades sobre cómo alcanzar objetivos futuros, armonización, convergencia, que es un tema que lo hablamos todos los días y que probablemente seguiremos hablándolo mañana y pasado. Pero en ese panel la respuesta fue: estamos lidiando con los problemas de hoy, como no estamos pensando en el futuro, ¿no? O eso es un tema del futuro, tenemos muchísimos problemas hoy para lidiar, ¿no? Y la verdad es que en la gestión para hoy y para mañana, abordando diferentes problemáticas. Pero ¿qué sucede con los objetivos y las metas estratégicas que sabemos que tenemos que cumplir, pero no lo estamos logrando en el día de hoy, o por falta de tiempo, o equipo profesional, o recursos financieros? Y para eso están los planes estratégicos. Una vez que tenemos una visión de futuro, que sabemos dónde queremos estar de acá a 5 años, que tenemos esa claridad en la cabeza, solo nos queda trazar la hoja de ruta, que no es menor, que es un gran trabajo. Lo importante es tener la visión y trazar la hoja de ruta para llegar de aquí a allá. Y para eso necesitamos un proyecto, necesitamos capacity building, capacidades, y necesitamos alianzas estratégicas. El proyecto es la mirada estratégica. Las capacidades son los equipos de trabajo y los recursos en general. Y las alianzas nos proveen del apoyo y la legitimidad social, porque de alguna manera estamos construyendo y robusteciendo nuestras democracias. Entonces, hoy sabemos que tenemos muchísimos desafíos que tienen que ver con nuevas tecnologías, como inteligencia artificial, con neuroderechos, con robótica, y pensar el GPA cómo va a abordar los nuevos desafíos que no solo tienen que ver con los temas, sino con la gobernanza del GPA, con la cooperación internacional, con cómo armonizar los intereses, ¿no? Entonces, partimos con una trayectoria muy importante de esta asamblea que reúne a 130 autoridades y que ya lleva muchísimos años de trabajo y creo que muy fructíferos. Y vamos hacia una mirada estratégica, ¿no? Y en primer lugar es recuperar las experiencias pasadas, las buenas experiencias. Hoy estamos finalizando un primer plan estratégico 2021-2023, que a mí me gustaría recuperar esa experiencia como muy positiva. Y tenemos una visión que yo creo que uno de los temas principales de esa visión tiene que ver con hacer oír la voz del GPA alrededor del mundo, en otros foros internacionales y en todos los espacios en donde se discuta protección de datos o nuevas tecnologías o cuestiones que tienen que ver con la necesidad de proteger los datos. Entonces, hacer oír la voz para mí es el objetivo fundamental, pero esto viene acompañado de la creación de capacidades y de los frameworks o los marcos de trabajo que de alguna manera tienen que ser compatibles, ¿no? Interoperables para todos los países. Entonces, eso es una mirada estratégica. Y para mí hay 5 aportes que hace el GPA como asamblea que reúne autoridades, pero también reúne a otros actores estratégicos vinculados con la protección de datos. Y lo que quiero rescatar son 5 aportes. El primero tiene que ver con que sintetiza miradas entre las autoridades y otros actores estratégicos, ¿no? Como los resultados del Global Privacy Assembly de alguna manera son una síntesis de diferentes racionalidades políticas y sociales, que también tienen que ver con diferentes países, diferentes posicionamientos políticos y diferentes tipos de actores. También tiene un aporte en la armonización de intereses, porque puede haber intereses que prefieran un estándar, hay otros países que pueden preferir otro, y estamos obligados a negociar y a conversar y a pensar los puntos de convergencia y no tanto los puntos donde no estamos de acuerdo, ¿no? Entonces, ¿cómo avanzamos con esos puntos de convergencia a través de declaraciones conjuntas? Por ejemplo, esta mañana tuvimos un desayuno sobre data scrapping, pero una declaración conjunta de varios países sobre data scrapping que me pareció muy interesante. Avanzamos con los diferentes frameworks de trabajo y guías. Avanzamos con el llamado humanitario, cuando fue el tema del COVID, se avanzó en conjunto con estrategias y acciones comunes. Bueno, esos son algunos ejemplos. Entonces, el GPA brinda marcos regulatorios de convergencia e impulsa nuevas regulaciones. Y también, para terminar 2 puntos más, construye capacidades para el enforcement, pero también para la producción de políticas públicas. Y acá por ahí hago una mención específica. No todas las autoridades tienen las mismas competencias, pero por ejemplo en la Argentina nosotros producimos políticas públicas, hacemos enforcement, regulaciones, y la combinación de estas estrategias nos dan un piso para trabajar la protección de derechos fundamentales como la protección de datos. Y por supuesto que el último punto tiene que ver con impulsar la cooperación internacional, y dentro de la cooperación internacional me parece que es fundamental el hecho de hacer un trabajo en las diferentes redes regionales y conversaciones entre las diferentes redes regionales. Entonces, con estos atributos que tiene el Global Privacy Assembly, vamos hacia un contexto en donde necesitamos tomar decisiones y medidas creativas y modernas que permitan generar herramientas para fortalecer el compliance. Tenemos que hacer la construcción de capacidades estratégicas de los DPAs. Tenemos que trabajar en fortalecer las políticas y sumar valor a las empresas públicas y privadas. Y en este sentido, el rol de la cooperación internacional me parece que es fundamental. Hay una metáfora que a mí me gusta mucho que tiene que ver con la regulación en la navegación, en la aviación comercial, ¿no? La aeronavegación, en donde todos los países invierten en medidas de seguridad para no tener incidentes, ¿no? Para que el avión tener la menor cantidad de incidentes de seguridad con los vuelos de los aviones. Y nadie discute si tiene que invertir menos, si tiene que invertir más. Hay un estándar de inversión y un estándar de reglas generales que es importante. Yo creo que el mundo de la protección de datos personales va hacia ese modelo. No es que no nos podemos subir a un avión y que alguien nos diga, ah, no, usted, su país, no necesita el cinturón de seguridad, porque usted todavía no ratificó o no tiene el estándar tal. Digamos, todos los seres humanos, todos los ciudadanos vamos a tener los mismos derechos, y de alguna manera tenemos que lograr esta convergencia y esta gobernanza global. Y en este sentido, desde Latinoamérica y desde la Red Iberoamericana de Protección de Datos, trabajamos también en instrumentos que, por supuesto, ponemos a consideración del GPA. Me parece que en este marco es donde empiezan a cobrar sentido las alianzas estratégicas con la GPA y las alianzas estratégicas hacia adentro de la GPA. Entonces, en este marco de mirada estratégica global, es importante consolidar y hacer oír la voz del General Privacy Assembly para maximizar la influencia, integrando las diversas realidades geográficas, culturales y regulatorias, así como también para fortalecer las capacidades de las autoridades de aplicación. Y este espacio es un espacio de armonización de intereses y de compartir visiones, pero también es un espacio de disputa geopolítica. Eso es una realidad, y creo que nosotros como miembros y con una mirada a 3 o a 5 años tenemos que proponernos un camino para alcanzar las metas y los objetivos que nos hemos propuesto, y creo que hay un equipo en el GPA que este es el último año de Argentina en el Comité Ejecutivo, pero hay un equipo importante que creo que va a llevar esos objetivos y esas metas a buen puerto. Muchas gracias.
Thank you very much, Beatriz, for these contributions on your vision. You're welcome. You're free to applaud. Yes. Yes, of course. So to continue, thank you very much. I will very briefly update you on what's the aim of our discussion today with our expert panelists. Our discussion today will center on how to deliver international cooperation in action and dive into the role that the GPA plays into this context. Our conversation will aim to identify areas where opportunities for international cooperation can be leveraged and explore new avenues. We are joined by a fantastic panel of experts and members of the GPA that gather expertise and experience in many international fora and represent many regions to ensure that while we dive into advancing international global cooperation, we also keep in mind the important nuances that exist at local and regional level, as well as the multifaceted and dynamic nature of cooperation. So, Cecilia, thank you for joining us. Well, she needs, unfortunately, to leave you early, but it will serve us to get us right into the practical reality of cooperation. Your authority cooperates actively with many peers in the region through memorandum of understandings, regular dialogues. Could you tell us a bit about this work and what other tools you consider that the GPA and regulators could use to increase cross-border cooperation, including cooperation on cross-border enforcement?
Sure. First of all, good afternoon, everyone, and thanks a lot for having us here. The PCPD Hong Kong has always valued the importance of developing and fostering working relationships with other DPAs to enhance the ability to address evolving data protection challenges and to effectively respond to emerging privacy threats in today's digital world. Amongst the various cooperation frameworks that facilitate putting international cooperation in action, as suggested by our discussion topic today, the PCPD primarily focuses on two forms of cooperation, one-to-one and one-to-many. For one-to-one cooperation, the PCPD establishes direct partnerships with other DPAs through Memorandum of Understanding. For example, in May this year, we signed an MOU with the Philippines National Privacy Commission to strengthen ties and foster closer cooperation. Last year, we renewed our MOU with the Personal Data Protection Commission of Singapore to establish an enhanced framework for collaboration and practical cooperation. And beyond Asia, we also have MOU signed with the Information Commissioner Office of the UK back in August 2020. These MOUs covering exchange of information, sharing of best practices, coordination and provision of mutual assistance, collaboration in education and training, etc., serve as formal agreements that outline shared goals and facilitate joint efforts in addressing data protection challenges. Apart from signing MOUs, the PCPD also maintains dialogue with both existing and new DPAs through online meetings, visits, and of course, face-to-face meetings during conferences like this one. For example, we had in the past visited the UK ICO to meet with staff of different teams to understand their strategies and priorities and their work. We visited the GPDP, the DPA in Macau, in May this year to hold in-person dialogue on potential areas of collaboration. We find that in-person bilateral meetings particularly invaluable for building sustained working relationships with our international counterparts. Also, these dialogues serve as channels for exchanging insights and keeping ourselves updated of the latest developments in the data protection field in other parts of the world. In terms of one-to-many cooperation, the PCPD participates in various international data protection networks such as GPA, EPA, and GPAN. Through these networks, the PCPD seeks to contribute to the global data protection community and amplify the voices of Asian DPAs so that the challenges and priorities of Asian DPAs are effectively represented. In this regard, GPA, with its numerous working groups, has provided an excellent and convenient platform for us to collaborate with other DPAs and to put shared priorities into action. Taking the International Enforcement Cooperation Working Group, in short the IEWG, as an example. The group, co-chaired by the PCPD alongside with DPAs from Canada, Norway, and Colombia, focuses on creating an environment that supports proactive and practical enforcement cooperation on current and pressing data protection issues. By fostering collaboration among the working group members, the working group facilitates the sharing of enforcement strategies, joint investigations, and development of common approaches to address transnational data protection issues. Often, as a first step to enforcement cooperation, members of the working group would convene ad hoc close enforcement sessions to delve into hot topics of mutual interest. These sessions provide a platform for TPAs to exchange views in confidential contexts, sharing insights, and exchange information with a view to collectively addressing emerging privacy challenges, engaging whether there is any appetite for further collaboration. If I may give an example, in April 2021, noting that there are many news reports of mass data scrapping incidents that harvested personal data of users of social media platforms, the PCPD Hong Kong initiated a close enforcement session with the IEWG members to discuss the incidents, share information about actions taken by different DPA members, different GPA members, and consider potential options for collaboration. The discussion continued with another close enforcement session capably led by the Australian DPA, and eventually the establishment of a dedicated subgroup on data scrapping under the IEWG to explore considered joint actions and set expectations of the privacy regulatory community around companies' obligations to protect against the scrapping of publicly accessible personal data. As you may all agree, actions always speak louder than words. So the IEWG also strive to transform their discussion into concrete deliverables. About 2 months ago, 12 DPAs, including PCPD Hong Kong, issued a joint statement to social media platforms and other websites that host publicly accessible personal data, highlighting the shared concerns of the DPAs over data scrapping and the global expectations on privacy protection in this regard. I would say that the joint statement has effectively raised awareness and sparked discussions among the general public about the growing concern of data scrapping and its privacy implications, especially when data scrapping has become a key source of training data for generative AI technologies. I think there are many other examples I could give on the collaborative efforts through IEWG, so allow me to name 2 more. Firstly, the transnational case map produced in 2022, which is an interactive online map that plots the transnational enforcement cases encountered by GPA members. One key characteristic of the map is that it groups the cases according to the types of transnational implication they have, such as whether there was extraterritorial application of domestic data protection law, whether there was cross-border data transfer, whether the assistance of other DPAs were sought, whether data subjects of other jurisdictions were affected. Another one is the open letter jointly issued by PCPD with other 5 DPAs back in 2020 during COVID-19 to companies providing video teleconferencing services, reminding them of their obligations to comply with relevant data protection laws and handle users' personal data responsibly. Positive responses were received from 4 major VTC service providers. With further engagement and discussions with the VTC service providers, eventually the 6 DPAs issued a joint statement on global privacy expectations of VTC companies in 2021, which highlighted the good practices reported by the major VTC companies in safeguarding personal data when they provide their services, while reminding the VTC companies of the possible areas of further improvement. So turning to the tools that GPA and regulators could use to increase cross-border cooperation, I would say that the GPA has already provided quite a number of useful and handy tools to facilitate cross-border cooperation. If I may, I would like to take the opportunity to promote the GPA Enforcement Cooperation Handbook prepared by the IEWG under the capable leadership of our friends from OPC Canada and ICO UK, last updated in 2021. It provides guidance and a common foundation for DPAs wishing to engage in enforcement cooperation, whether with other DPAs or authorities from other regulatory spheres, by setting out the ways through which DPAs may lay foundations for enforcement cooperation and the models and strategies DPAs may employ in different contexts and circumstances. It also contains practical templates such as enforcement cooperation checklists, joint investigation plans, and MOUs. Separately, the GPA Enforcement Cooperation Repository, which serves as a digital library on the GPA website, is also a very useful tool. It centralizes links to publicly available and non-confidential resources of value to the global community of DPAs, including media statements, public documents, court judgments, guidelines, and enforcement decisions. So building on the existing resources, I think arranging more capacity building or experience sharing workshops focusing on cross-border cooperation can be a step forward. Another one is collaboration amongst working groups. This may also be further explored to stimulate thoughts and facilitate joint efforts in addressing data protection challenges. So lastly, let me thank again everyone here and for the opportunity to share Hong Kong's experience.
Thank you. So, Josefina, as Commissioner of the INAI in Mexico, but also chairing the GPA Assembly, what's your experience? What you can share about this such a prominent responsibility that you have had in the last years, and how do you see what's your vision and the vision of Mexico for the future of the GPA?
Gracias. Gracias, Dolores. Pues bueno, antes yo quisiera iniciar lo que seguramente todos sabemos, pero recordar que justo la Asamblea Global de la Privacidad está creada para hablar de la cooperación internacional en un contexto multidisciplinario. Somos 138 integrantes al día de hoy, pero no solamente autoridades de datos de todo el mundo, sino también hay observadores que son académicos u organizaciones internacionales. Entonces, evidentemente, la esencia de la GPA es justamente ser un foro global que reúne autoridades de protección de datos de todo el mundo y especialistas en la materia. Su principal propósito es justamente fomentar el intercambio de buenas prácticas, conocimientos y experiencias con un enfoque en promover la colaboración global para que las autoridades reguladoras podamos garantizar el derecho a la privacidad y a la protección de datos. Yo quiero hablar un poco del plan de trabajo que va a ser aprobado en la próxima sesión privada y que, bueno, la comisionada, la directora de la Autoridad de Datos en Argentina, que es quien coordina este subgrupo, nos va a platicar con más detalle y ya antes nos hizo referencia. Miren, para tener justamente esa brújula de cómo debe de funcionar debidamente la cooperación internacional para GPA, desde otra perspectiva, nosotros hemos identificado de estos 3 objetivos importantes con diferentes estrategias lo que hemos denominado algunos principios, porque de esta manera yo quisiera dejar sobre la mesa algunas reflexiones de los aspectos que nos parecen los más importantes. Bien, en primer lugar, yo quisiera destacar que, bueno, hoy todos coincidimos en que debemos trascender fronteras y trabajar no solo de manera colaborativa e integradora, sino además abordar algunos desafíos que hoy tenemos en la era digital. En realidad no tenemos legislaciones globales, regionales o nacionales específica en materia de tecnologías de la información y comunicación, que durante esta sesión abierta y los próximos 3 días en sesión cerrada abordaremos en GPA. Entonces, con esta perspectiva de principios importantes, quisiera destacar, en primer lugar, armonización de estándares. Sabemos que los datos fluyen libremente a través de las fronteras y no están alineadas las regulaciones. Hace rato yo decía, no todos los países del mundo tenemos en una constitución reconocido el derecho humano a la privacidad o el derecho humano a la protección de los datos personales. Pero además, las legislaciones por región no son las mismas, y no me refiero a que sean idénticas. Tenemos claro que no es lo mismo armonizar que homologar. Más bien estamos hablando de convergencia o de equivalencia en esta legislación, en esta normatividad. Desde la GPA tenemos esa fotografía muy clara, me parece, y quiero insistir en este buen principio de reconocimiento de derechos fundamentales, pero además identificar coincidencias y diferencias en las legislaciones, porque por región podemos empezar a hablar de estándares mínimos regionales. Tenemos algunos ejemplos en donde ya venimos trabajando, por ejemplo, en la Red Iberoamericana de Protección de Datos Personales, hemos avanzado en el tema de cláusulas contractuales modelo. Igual, por ejemplo, ha hecho ASEAN en el sureste de Asia en cláusulas contractuales tipo. En la región del norte de América, México, Estados Unidos, Canadá, tenemos el Tratado de Libre Comercio y bueno, ahí lo que está normado son las reglas de APEC, CBPR. También tenemos los principios de OCDE. Entonces, para Mercosur también tenemos las propias reglas. Entonces, lo importante, me parece, en esta armonización de estándares es identificar coincidencias, pero sobre todo convergencia y equivalencia, porque sabemos que cada país y cada legislación es completamente diferente. El segundo principio que queremos dejar sobre la mesa es el intercambio de información. Justamente a través de esta Asamblea Global de la Privacidad y de otras redes internacionales que agrupan principalmente autoridades de protección de datos por región, tenemos ejemplos muy interesantes en donde coordinamos acciones para llevar a cabo investigaciones. Les quiero referir, por ejemplo, en la Red Iberoamericana de Protección de Datos, un ejemplo interesante es que nos coordinamos, todas las autoridades que integramos esta red, para iniciar investigación en cuanto al tratamiento de datos en ChatGPT. Se está en ese proceso, cada país con su propia legislación, cada autoridad hasta donde le da también su legislación. El tercer principio es la formación de capacidades. Sabemos que no en todos los países, no todas las autoridades tenemos el mismo nivel económico y humano en las capacidades de especialización, de formación, de actualización. Sabemos que el derecho a la privacidad es un tema multidisciplinario. Queremos seguir hablando de servicio profesional de carrera, estar actualizados, pero garantizar exactamente que este tema, especialmente de autoridades, sea de capacidades. En el cuarto principio, queremos subrayar la facilitación de flujos de datos transfronterizos. Hemos venido diciendo, y bueno, en general, quienes somos autoridades de datos, vigilamos y garantizamos que se cumplan todos los principios, deberes, obligaciones de la legislación de la que somos garantes. Pero desde la perspectiva ciudadana se busca poner en el centro a la persona, hablar de derechos humanos, hablar de dignidad y entonces hacer justamente ese clic entre autoridades, personas titulares de datos personales, pero al mismo tiempo no hablar de colisión entre comercio electrónico, por ejemplo, y flujo de datos transfronterizos, siempre que sea de manera segura y cumpliendo la regulación de la materia. El quinto principio que queremos abordar se centra en abordar tecnologías disruptivas. En este programa de la sesión abierta y en los próximos días que hablaremos de la sesión cerrada, por supuesto que tenemos temas de tecnologías de la información y comunicación, hablaremos de inteligencia artificial generativa, hablaremos de temas novedosos como neurodatos, neuroderechos. Entonces, bueno, tenemos que identificar con claridad cómo podemos adaptar las regulaciones y los principios existentes a estos nuevos paisajes tecnológicos. Sabemos que además de ser multidisciplinario, cada país decide cuáles son las autoridades que en ese tramo de regulación nos corresponde hacer a cada uno de nosotros. Por último, queremos dejar manifestado que es un muy buen principio que en las constituciones se reconozca el derecho a la privacidad como un derecho humano, es un derecho fundamental. Entonces, a mí me parece que independientemente de las decisiones que cada país toma cuanto a la forma de regularlo, sí es un muy buen principio que sea una constitución política, la ley fundamental de cada país, de este reconocimiento, porque cuando hablamos de derechos humanos necesariamente nos vamos a la persona y a la dignidad de la persona, y de ahí hablamos de leyes reglamentarias, y ya cada legislatura nacional identifica que de acuerdo a sus realidades y a su diversidad le acomoda más. Pues bien, entonces, concluyendo, la cooperación internacional en la GPA no es solamente un objetivo, sino yo diría que es el corazón de los trabajos que realizamos. Es ese enfoque colaborativo y de armonización que llevamos a cabo en todos los grupos de trabajo. Por decirlo de alguna manera, tenemos grupos de trabajo temáticos en donde hay un coordinador, se llevan a cabo, en ocasiones la conclusión son resoluciones, como ahora vamos a aprobar algunas en la próxima sesión cerrada, pero analizamos, discutimos, reflexionamos y tenemos conclusiones muy concretas en relación a acciones a seguir de cada uno de estos temas que llevamos a cabo. Estoy terminando. Desde capacitación, inteligencia artificial, grupos vulnerables. Entonces, me parece que justamente es el espacio, esta Asamblea Global de la Privacidad, para tener soluciones concretas o una ruta, una brújula en lo que queremos buscar en el tratamiento de protección de datos personales. Yo concluiría nada más insistiendo en que por supuesto que la cooperación internacional es indispensable para que podamos garantizar el debido tratamiento de datos personales, especialmente en esta nueva virtualidad.
Muchas gracias, Josefina. So from Asia to Latin America and now to Europe. Ulrich, as Federal Commission for Germany, you are a member of the Executive Committee of the GPA, and also you have participated in the G7 meetings of Data Protection and Privacy Commissioner. Could you tell us about these opportunities you see for creating synergies between different forums, such as the G7 and the GPA?
Yeah, thank you for having me and having an eye on G7, which is an institution much younger than the picture you took for the for the board, which is almost 10 years old, and the G7 roundtable of DPAs is now 2.5 years since we followed initiative from our British friends, Elizabeth Denham at that time, when she saw that the G7 meeting with all its economic power, with all the political power, has more and more digital topics on the agenda. And she was the opinion, and as others, 6 DPAs followed that immediately, that we need a voice in this process as DPAs, following the topics, giving advice, and drawing attention and giving awareness to the debates which are going on among DPAs. And so the first, at that time, digital or virtual meeting was 2.5 years ago, following an in-person meeting last year in Bonn and this year in Tokyo, and establishing not only an annual meeting, but a working group structure in between these meetings, with the first priority on the topic of data free flow with trust, following the Japanese initiative on the G7 summit. Seeing that the debate we had here in the GPA, and I remember the resolution of the GPA, which stated out that we need interoperability between different data protection regulations, but also a convergence as one of the ideas of not lowering the level of data protection, but creating a worldwide, at the best, worldwide high level on data protection, even if we are fighting against a trend of segmentation of the internet to different groups of services and products, and without the ability to transfer data among providers, individuals, and companies in this group. So that was the very founding idea, and the 2 communiques of Bonn and Tokyo stated out not only the position of the G7 DPAs in this roundtable, but shows the ability that such a specialized network gives to highlighting the work of the GPA. In this communique, you find at a number of points the linkage to resolutions of the GPA, to debates which has gone in the GPA, and the attention which is given to that process, especially close to the summit of the prime ministers and head of states, gives us the opportunity not only to give this information to the delegations, the political delegations, but also to the media, which are the ideas DPA can contribute to these economic discussions on digital topics. So we see that the difference from such a group of 7 DPAs to the GPA, which developed in its 45 years since the first meeting in my hometown of Bonn, 1979, as an exchange of a group of data protection commissioners to a group which is not only a network of a network of DPAs, a network of institutions, but also installed in the last years, and you said that perfectly, even a structure of working together in between the annual meetings. So, but a group like the G7, which is very close to a political debate, and which is more agile and small and can work very quick on topics, can have both opportunities, the highlighting, and the other one is giving an impulse to the work of the GPA. And this is the second idea. This working group we installed should not only focus on the long term on the DFFT, but on other topics too. And to give an example from my debate back home, almost all the time I go to the parliament or to the government, and even I was myself for 20 years member of the parliament, the reaction is always, you're the hardliner in data protection. No one else in Europe, no one else in the world has the same ideas. When I bring them the resolutions of the European Data Protection Board and say, no one outside the European Union, And it was so good to see at the meeting in Bonn when our friends from North America, from Japan, come in and said, so ideas like data minimization, purpose binding must be the very basic point for a data-free flow with trust. With that resolution, with that communique, we could go back and show our government again that they should hold up these principles in negotiations about international accommodations for data transfer. And so this was a very quick process contributing to the work of the GPA as a network. And this is the thing we are trying to work on, being a best practice for highlighting the work of the GPA and contributing to it.
Thank you. Now moving, thank you very much. Now moving to Canada, trying to be as global as possible. Well, we know that data protection debates are no longer complete if we do not include other topics, such as competition, consumer protection, and antitrust, etc. Is there any lessons that you can share, including from your national experience, on this cooperation, and what could be the opportunities to further expand on it? Thank you.
Sure, thank you. Good afternoon, everybody. My name is Gregory Smolinek. I'm the Deputy Commissioner for Policy and Promotion at the Office of the Privacy Commissioner of Canada. To answer your question, we've recently formed a, a cooperative forum for digital regulators in Canada. It involves us, our office, the OPC. It involves our Competition Bureau and our telecommunications and broadcasting regulator as well. But it's early days. We've had a few meetings. We're setting a common agenda. There's research involved. We have a special focus in that forum on AI. But I would say that it's early days for us. We look to Britain a little bit for an example of such a forum and interregulatory cooperation, and we look for other examples around the world as well. I did want to tell you a little bit about what my office is up to internationally in terms of cooperation. Give you a little bit of an overview of what we've been doing recently and where we're going as well. So it's obvious that data flows internationally. Cooperation is, I would call it an imperative. But how do you get there? So for like this, obviously, we meet all week, we're talking, we have this panel. These are excellent initiatives. And there's a lot of good work being done between the conferences of the G7, between the conferences of the GPA, working groups. These are kind of institutionalizing, habituating us to continuing the work of what perhaps in another time were just annual events. So these are great initiatives. At the same time, we look at the work of the GPA on standards, the working group on standards that has identified common common principles, shared norms, and we think, how can we build upon those norms that we share, those shared principles? It's complex, of course. There's regulatory differences between different regulators, different laws apply, different jurisdictions. We even have to deal with different legal systems, different languages. So it's not the easiest thing, but those common standards and common norms, we can identify them. We can also, to your comments, identify common strategic objectives and figure out how to resource them and figure out ways in which we could attain them. So it sounds kind of basic to say, but can we identify common ends that we could seek together? The strategy exercise, these are basic things, but they're easier said than done. So we need more of this kind of awareness. We need this kind of a global approach. So in the months and years to come, we're looking to reinvigorate our international activities. We're looking to activate our office on the international level. To start with, we'll be hosting the Berlin International Working Group on Data Protection Technology, chaired by Professor Kelber. And that will be on December 7th and 8th in Ottawa, Canada. There will be a special session as well devoted to generative AI at that meeting. And we're looking to promote the work of the Berlin Working Group a little more broadly in the hosting of this event. That's to start with. We're investing in channels to cooperate and exchange information. Like you, we've just recently, as a matter of fact, I believe it was only yesterday, we signed a memorandum of understanding with our colleagues from the Philippines. We're working with specific data protection authorities on focus areas. So to that end, just to give you an example, Commissioner Dufresne will be traveling to Italy in the coming year to attend events in Italy to cooperate with the Italian Garante on specific initiatives. We're working with NGOs, civil society actors. We're looking to further our work with the UN Special Rapporteur. And this is not just our office, but the GPA working group that we chair on data protection and other rights and freedoms. We're collaborating with the UN Special Rapporteur. We're seeking to further that collaboration. After Germany chaired the G7, now it's Italy's turn in the coming year. And after Italy, we have our turn to chair that meeting. So we're already turning our minds to the agenda for our chairing of the G7 data protection authorities. I think we have a very solid foundation with the working groups. There's a solid track record, I think, in the GPA, a lot of excellent work being done in strategic planning and in the existing working groups. I'd point out that my colleague Brent Homan has provided outstanding leadership to a couple of GPA working groups, the International Enforcement Working Group, the Digital Citizen and Consumer Working Group. Some of these groups also address some of these interregulatory affairs that you were talking about, these challenges, how to cooperate between regulatory spheres. So there's a lot of work. There's excellent work being done to develop and further advance the goals of interjurisdictional investigations as well. So this is another area that we're looking at. And I mentioned this working group on data protection and other rights and freedoms that we've chaired, and this applies in different areas. We've been, our office, very much promoting the notion that privacy is instrumental to other rights and freedoms. And through the working group, through the original GPA resolution as well, somewhat paradoxically, I'd say, this is not an unusual concept in many places in the world. But in Canada, it hasn't actually been reflected as fully as we'd like to have it reflected in our legislation. But now we see our government is accepting the idea of recognizing privacy as a fundamental right in the legislation that's now before Parliament. And I do believe that some of that effect domestically has come about through the work of the GPA in promoting the idea of privacy as a fundamental right. And finally, I just wanted to point out that we're so enthusiastic about international cooperation that just this week, we have established a new international relations directorate within our office. Previously, the work was kind of dispersed. And my colleague, Miguel Bernal Castillero, who's sitting right there. Miguel, stand up and let everyone see you, because this is your new point of contact on international collaboration with the OPC. He's leading that directorate as of this week. So, as I mentioned, we're looking to get even more active internationally, to promote more international collaboration, and to provide more leadership to various international networks that we participate in. AFA-PDP, G7, GPA, APA, maybe Common Thread even? So get everything reinvigorated a little bit. So those are some remarks to start with.
Okay, thank you very much. Last but not least, Omar, Mr. Commissioner of Morocco. You are a member of the Executive Committee of GPA as well, and your authority is also part of regional linguistic network, meaning that international cooperation is for you as well as part of your daily life. As Morocco hosts the Secretary of the African Network, and considering the increasing importance of regional networks, how do you see the interplay between regional networks and global, such as the GPA? Do you see them as complementary or source of competition?
Merci de m'avoir donné cette occasion d'intervenir dans ce panel. En fait, je voudrais interagir et répondre à la question en plantant un peu le décor, en définissant le contexte. On considère que, et pas que nous, tout le monde considère que la protection des données à caractère personnel est un domaine transverse qui traverse toute la société et tous les pans de la société. La protection des données à caractère personnel se construit au fur et à mesure. La façon avec laquelle on appréhendait la protection des données il y a 40 ans n'est pas la même que celle avec laquelle on la gère aujourd'hui. Et on considère aussi, comme tout le monde ici, que la protection des données à caractère personnel se construit à l'international. C'est en échangeant entre les uns et les autres qu'on arrive à trouver des options plus opportunes que d'autres. En fait, le piège dans lequel on ne doit pas tomber, c'est de traiter la protection des données à caractère personnel comme une solution technologique, alors qu'elle est une problématique sociétale. C'est au sein de la société qu'on trouve les citoyens, et ces citoyens qu'on doit protéger et protéger leur vie privée. Et donc, c'est de cette manière-là qu'on doit travailler. Alors, si ceci est le contexte, il y a un autre élément. De plus en plus, on voit émerger des plateformes internationales qui, elles, ont des approches globales. Donc, quelque part, nous avons deux défis. Parfois, on n'a pas le temps de réfléchir tout seul. Et parfois, on a besoin de réfléchir tous ensemble parce que les uns et les autres peuvent enrichir le débat et apporter la convergence vers des solutions utiles. Donc, on a besoin de raccourcir le temps de réflexion. Et pour raccourcir le temps de réflexion, on a besoin d'augmenter le nombre de personnes qui réfléchissent ensemble. Deuxième élément qui est à considérer, c'est que les plateformes qui peuvent agir et reconfigurer le domaine de la protection des données personnelles sont des plateformes qui ont des politiques globales. Donc nous aussi, on a intérêt à avoir des politiques globales. Je vais vous citer juste un petit exemple d'une plateforme que je ne citerai pas, mais qui, dans ses conditions générales, parle des données à caractère personnel qu'elle souhaite manipuler. Les données à caractère personnel de vos personnes peuvent inclure, mais sans s'y limiter, les coordonnées telles que le nom, l'adresse, le numéro de téléphone, du domicile, du mobile, le numéro de fax, l'adresse e-mail, les mots de passe, les données relatives à la famille, au mode de vie, à la situation sociale telle que l'âge, la date de naissance, l'état matrimonial, le nombre d'enfants, le nom de l'époux ou de l'épouse, les enfants, les détails relatifs à l'emploi, le nom de l'employeur, l'intitulé de poste, les fonctions, l'historique professionnel, le salaire et autres avantages, les compétences professionnelles, le niveau d'études, les qualifications, les numéros d'identification et les coordonnées professionnelles, les détails financiers, les biens et services fournis, les identifiants uniques recueillis auprès des appareils mobiles, des fournisseurs de réseaux et de données, etc. etc. C'est assez long. Nous, si je prends l'exemple de l'autorité dont j'assure la présidence, si par rapport à notre gouvernement, on dit là, c'est pas possible, là, c'est exagéré, c'est pourquoi toutes ces données, on va nous prendre forcément pour des conservateurs, des gens qui n'ont pas compris la vie, des gens qui n'ont pas compris l'intérêt du digital, etc., etc., etc. Donc nous, on a intérêt et on a besoin de collaborer dans une institution et dans une organisation comme la GPA pour échanger avec nos collègues, voir ce qui se fait ailleurs, voir si cette plateforme demande la même chose en Europe, demande la même chose au Canada, demande la même chose aux membres du G7, et essayer de créer et de contribuer à une vision globale. Donc encore une fois, l'aspect lié à la protection des données, pour nous, ne peut pas se gérer de façon isolée. La GPA, ce n'est pas un confort, ce n'est pas un luxe, c'est une nécessité. Alors, je me souviens de l'Assemblée générale d'Istanbul où la présidente de la GPA avait insisté sur l'importance des groupes de travail et l'importance que les organisations régionales puissent collaborer entre elles pour ne pas refaire la même chose, mais pour renforcer le travail des uns et des autres. Et je pense que c'est une approche très pertinente et très utile. Et donc, on a pu voir quelques exemples, mais j'imagine que c'est des choses qui vont se renforcer quand des groupes de travail, parfois par le hasard de la communication, décident de travailler ensemble ou de partager des choses. Et je pense que la lettre conjointe du groupe de travail qui a été piloté par le Canada est un exemple très parlant qui permet de construire. On a besoin de construire tous ensemble. Lorsqu'on regarde ce qu'il y a à faire, il y a tellement de choses à faire, encore une fois, que la communication doit être importante et nécessaire. Nous sommes en train de travailler pour refondre la loi, notre loi. Et dans l'organigramme, dans le décret d'application que nous travaillons, nous avons fusionné ensemble, dans le même département, les études et les relations internationales. Car nous pensons que pour faire les études, on ne va pas réinventer la roue à chaque fois, on ne va pas recommencer à zéro. Et qu'on a intérêt à échanger avec nos amis dans toutes les DPA de par le monde, dans les groupes de travail, pour savoir ce qui se passe et gagner du temps, parce que justement, nous avons besoin d'aller en profondeur et de ne pas faire des études de 6 mois, 3 ans. On n'est pas en train de faire des doctorats ou des thèses. Je voudrais dire que lorsque on travaille, vous avez évoqué la dimension africaine, et donc la CNDP et secrétariat permanent du réseau africain. Nous avons également une approche pour partager au maximum, parce qu'on ne peut pas, si on veut accélérer la protection des données dans certains pays, dans certaines zones, on ne peut pas laisser les gens travailler tout seuls. Et donc, nous considérons aussi comme membre exécutif du comité exécutif de la GPA que nous devons contribuer avec vous tous pour faire en sorte qu'il y ait un maximum de pays africains qui soient membres et qui rejoignent la GPA pour profiter de l'état d'esprit de la GPA. En dernier lieu, ou en avant-dernier lieu, je dirais qu'en arrivant aux Bermudes, et encore une fois, merci pour l'hospitalité d'Alex White, tout le monde nous parlait du triangle des Bermudes. Donc je vous propose, lors de cette 45e Assemblée générale de la GPA, de remplacer le triangle des Bermudes par le triangle de la protection des données. Alors c'est quoi le triangle de la protection des données? C'est un triangle, bon, comme tout bon triangle, il y a 3 sommets. Il y a le sommet de la personne concernée, le sommet du responsable de traitement, le sommet de l'autorité qui doit s'arranger et surveiller que le contrat qui existe et l'échange entre la personne concernée et le responsable de traitement est conforme à la loi, la gestion des notifications, la gestion des plaintes, la gestion du contrôle et des sanctions. Donc en fait, on a ici, avec le triangle qui va remplacer le triangle des Bermudes, on va avoir une dimension de métamodèle. Et comme il est dit par les uns et les autres, en fait, si on passe notre temps à vouloir s'assurer que l'article 2 de la loi dans un pays est conforme ou ressemble à l'article 25 de la loi dans un autre pays, on ne va pas s'en sortir. On doit élever le débat et s'intéresser à une vision de métamodèle à partager tous ensemble, sur laquelle on peut peut-être mieux travailler, mieux appréhender les différences et les progrès que les uns et les autres vont faire. Mais en tout cas, je pense que le travail initié et encadré au sein de la GPA est un travail, et ce n'est pas de la complaisance, ce n'est pas pour faire plaisir, c'est un travail qui est fondamental, important, et je m'arrête là, juste en disant que on a tellement et on travaille tellement ensemble que vous avez permuté ma photo avec celle de Ulrich. Donc ça montre qu'on est dans le même état d'esprit. Merci.
Merci. So, since we have a few minutes, I'd like to ask all of you, and please feel free to step in. There is no order. Feel free to step in and answering. What do you think that, or how GPA could contribute to foster international enforcement and enforcement cooperation across regions? I know that you all are members of data protection networks, and even that, for instance, in a world when you are always facing most of the time compliant issues by often the same companies, how do you think that GPA could support you, or how do you envisage in the future to focus more on enforcement cooperation across regions, not only within your region? Of course, Europe has lots of experience on this, but you also have on the GDPR Article 50 that includes, that would be also good if you share, like you have already in your regime, enforcement cooperation provisions across regions haven't been used yet. Are you thinking about it? Do you need it? It will be beneficial for you. Yeah, and even for companies, having some definitions and unifying criteria across, generating a level playing field across regions on certain topics. I'm thinking on OpenAI, but there's a lot of things that we all have in common, we all face, but we all worked separately in a way. So please go ahead. Whoever feels like it.
So
yes,
maybe me first, because you had the point with the GDPR idea of common enforcement. So even we have to work on it. There are more and more situations where this kind of joint enforcement takes place inside the GDPR, and that shows that would be not so easy to really create a kind of, now we do a joint enforcement against some branches or some vendors of information. But I think there will be two things which can be a contribution to this idea. The first one is the exchange of information, the build-up of capacities, which is also a part of the work of the GPA, to understand what is the work others have done and to repeat just these experiences. And that's one of the reasons why I came to Bermuda, to learn about experiences from colleagues. And the second one is, in the moment we identify some rules in data processing, then these rules, supported by so many of us, is a very good start for enforcement of the law. Even the law maybe is different from region to region. So the resolutions, if prepared and made well, gives a good chance for such inter-regional cooperation in enforcement.
And do you envisage, and please step in, do you envisage some sort of, in the future, some sort of network of networks? And if so, could GPA be the origin of some further development in enforcement cooperation?
Yeah, there is another network with Japan where DPAs are working on enforcement, and to have a close contact with the work which is going on in Japan, and we share the same members. This could give the GPA a certain aspect in this work. And I think the aspect is more of this exchange. This is also done in Japan, and the other one is of really promoting basic interpretation of rules in data protection. And this, again, is then a thing which can be used in another network. And this could be the role of the GPA as a kind of a United Nations of DPAs, the positive understanding. The positive understanding without the same need for reforms and no Security Council with vetoes.
No vetoes.
Yeah.
Okay.
So different at that. Okay, I take back the picture. Okay. As network of DPAs.
Yeah. Beatriz?
Yes. Well, I agree. Yo estoy de acuerdo con lo que dice Ulrich. Yo pongo un punto de vista también de necesitamos regulaciones desafiantes para poder hacer un enforcement que sea armónico con el resto del mundo. Hay un tema que es el doble estándar siempre, ¿no? Entonces, donde hay el GDPR, hay un estándar y hay un enforcement, y por ahí en otros países menor. Entonces, me parece que tener regulaciones desafiantes y un trabajo bien importante de promoción, educación, concientización ciudadana, me parece que es también importante para el enforcement, porque si hay una demanda de la ciudadanía para el cumplimiento, creo que eso nos da una herramienta más. Creo que se trata también de construir, para poder hacer el enforcement, las capacidades y el poder suficiente para garantizar ese cumplimiento, ¿no? Y respecto a las redes, yo creo que uno visualiza en el GPA que hay diferentes redes regionales. Bueno, yo pertenezco a la Red Iberoamericana de Protección de Datos, que junto con Josefina también estas estrategias de acción conjunta para una investigación, por ejemplo, con el chat GPT, me parece que es importante, más cuando no tenemos la herramienta del ámbito extraterritorial todavía como una herramienta de nuestras legislaciones. Me parece que son diversas formas de garantizar el enforcement, y además se pueden pensar otras acciones de política pública que promuevan y de alguna manera mejoren el enforcement en cada uno de los países.
Yo quisiera, desde una perspectiva de redes internacionales, primero decir que regionalmente definitivamente tenemos que buscar no solo política pública nacional, sino estándares regionales muy claros, independientemente de que la legislación de cada país, por supuesto que está identificando sus propias realidades. Pero no nos podemos quedar ahí, porque decíamos hace rato, a ver, tenemos la Red Iberoamericana de Protección de Datos Personales con algunos ejemplos muy interesantes que hemos extrapolado a otras redes. Tenemos el Foro de Autoridades de Privacidad de Asia-Pacífico, donde también hay grupos de trabajo temáticos, y en realidad lo que hacemos en GPA, mañana lo haremos, no recuerdo si es el jueves, este resumen de lo trabajado, lo avanzado y lo concluido en las diferentes redes regionales. Entonces, compartiremos también, bueno, aquí Omar nos platicará mejor de la red africana, que también ha trabajado en esquemas de convergencia. Entonces, ASEAN es un buen ejemplo del sureste de Asia, que ha estado trabajando en la cancha, por llamarlo de alguna manera, de las cláusulas contractuales tipo. Iberoamérica también hemos estado en ese sentido. Pero, en resumen, yo quisiera señalar que, así como tenemos Red Iberoamericana, Red Africana, el Foro de Autoridades de Privacidad de Asia-Pacífico, está ASEAN, La Asamblea Global de la Privacidad reúne al mayor número de autoridades, especialistas y organizaciones internacionales en materia de privacidad y de protección de datos. Muchos formamos parte, en el caso de México, de la Red Iberoamericana y de autoridades de privacidad de Asia-Pacífico y de la Asamblea Global de la Privacidad. Pero como Omar de Marruecos forma parte de GPA, compartimos información. Entonces, en resumen, yo me quedaría con esta parte de inclusive tener algunas leyes modelo con los mínimos indispensables en materia de privacidad, buscar enseguida estándares regionales, creo que son esfuerzos que ya en algunas regiones se vienen haciendo en Iberoamérica, en el sureste de Asia. Europa, bueno, tienen ya legislación de alguna manera más integrada, para de ahí brincar a lo que sería la globalidad. Esa oportunidad, esa gran oportunidad de compartir información y de extrapolar los resultados de todas estas diferentes organizaciones internacionales, creo que esa ventana de oportunidad justamente está en GPA por estos 138 integrantes entre miembros y organizadores que además somos parte de otras redes regionales.
Thank you very much. If we have exceeded our time, but if any one of you would like to say some final words, you are most
I just
welcome.
wanted to add to this discussion, there is the International Enforcement Cooperation Working Group as well, so that addresses these kind of issues systematically as well. And training is one of the places that you could further the goals.
And if I may add on to that, the International Cooperation and Enforcement Working Group actually has a capacity building workshop this Thursday on managing data breach notification. It's a closed session, but we hope to see you there.
There you go.
Okay, there
Concrete.
You go. Convergence in action. Okay, well, thank you very much for joining us. Thank you.
So does it do it internally? It doesn't. I don't see no fader writing. Hey, well, how that go up?
It senses which mic.